Recording in
Mr. Baloyi,
progress.
there? Ms. Baloyi?
Good afternoon, Chair. I'm here.
Thank you. Thank you. Welcome back. Before I proceed to the cross-examination, I'm just going to give the last 5 minutes to Advocate Mayosi.
Thank you. Thank you, Chair, and thank you for the indulgence. I'm going to be about 10 minutes. I missed just covering this issue with the witness. We furnished you with some emails yesterday that we obtained from the Office of the PPSA, correct?
Correct.
I just want to touch on some few aspects of the emails. We won't go into this deep. Your evidence was that some of the investigation, I think in particular, you spoke about the rogue unit investigations. Some of these matters you would be involved in, and some of the communications went directly between the investigator and the PP, correct?
Correct.
Tsepo, if you can go to those emails, bundle F, item 107. If you start at item 2164, page 2164, you are not involved in all of them. I'm just going to tell you, I'm just going to take you to some of them that you are involved in or are copied in relation to some of the matters that your affidavit mentions, and just ask you to confirm whether you're aware of that email and what your involvement in that matter was. 2164, as you can see, it's an email from the PP to yourself, and in the subject line, it says that it's a final version of the Gugile Ngwindi Section 79 notice. Do you see that?
Yes.
So you were involved at these stages of this investigation, right up to the Section 79?
Yes.
Were you involved in the report at all thereafter, the final report?
Yes, I was involved in the final report.
Okay. Here we go to 2171. This is another one where you are copied in. It's an email from Mr. Muntu Sitole to, amongst others, to the PP actually, amongst others, and you were copied in as well. Do you recall? It says in the subject line, it's a second subpoena, Honorable Minister Pravin Gordhan. Do you recall this email at all? And then can you shed any light on your involvement in this particular matter?
Yes, I was in. I know about it. It was after he failed. Minister Gordhan failed to appear, and then there was an opinion that was, secured for that.
Yes, you said down below the email from the PP, in which you are also copied. Can you recall? It's still about the same issue, which is the second subpoena to the Honorable Minister Pravin Gordhan. Are you able to shed any light?
Yes, I remember. This is the matter that when we requested document from SARS, the former acting commissioner, provided information to us, and then with a legal opinion on, individual text information.
Right.
And yes, and then the PP was not happy about that, and then legal services was instructed to look for a second opinion.
All right. Is that what is meant by her line that legal urgently get an opinion from Skakana SC, which will contradict manager's opinion on availing individuals' tax information?
Correct.
Okay. Can we go to 2188, please? Just put the whole email up? Yeah. This is another email in which you were copied, Ms. Baloyi, from Mr. Sibusiso Nyemba, whom I understand was the chief of staff or political advisor at the time, who has since passed on, we are told. What do you recall about this particular email? Show the whole email, please, Tsepo. Yeah.
It was around issues of funding, issues are, in terms of, if I remember quite well, it was around the fact that, we do not have money, to fund, certain obligations, and that, we should be looking for funding around those matters. So I think the other issues for me, it was just talking about the implications of not receiving adequate funding. And then issues around the last paragraph, I've never met Advocate Ngobeni, and I'm not sure as to what that was all about.
But according to Mr. Nyeme, the idea that he is mooting in this email about instituting proceedings appears, or he suggests that it was first mooted by Advocate Ngobeni to him.
Yes.
All right, go to 2190, I think. This is another one where you were copied on. Ms. Baloyi, do you recall what this communication?
I can't recall on this one, but I have been copied on it, but I can't recall what was it all about.
In the subject line, it's the investigation into allegations of, it suggests that it is what you refer to in your affidavit, the so-called rogue unit investigation, correct?
Yes.
But you can't shed any more light for the committee as to why you would have been copied here?
No, I can't recall why I was copied on that email.
I have no further questions, Chair, for this witness. Thanks.
Okay, exactly 7 minutes. Thank you, Advocate Mayosi. Thank you. With that, I'm now going to recognize and invite Advocate Dali Mpofu to start the cross-examination, and we'll do that from now until 5. We'll review at that point. Thank you. Advocate Mpofu.
Thank you, Chairperson. Good afternoon, Ms. Ngobeni. Ms. Baloyi.
Good afternoon, Advocate Mpofu.
Okay. Yeah, Deputy General. Deputy Director General.
I knew you were going to go there.
No, it's fine. Yes, ma'am, you had the exchange that...
Can you just reposition yourself? We're not hearing you properly.
Okay, let me just press the magic button. How is that, Chair?
That's much better. Thank you.
Okay, all right. Yeah, ma'am, so on a more serious note, you had the exchange I had with the chairperson this morning about the relevance of your evidence, correct?
Correct.
And you are not, are you surprised that the independent panel found that your evidence is not relevant to the work of this committee?
Advocate Mpofu, I'm appearing before the committee to assist it to do its work, but this is not my case. So about the relevance or not, that is not my call.
Yes. No, I know it's not your call, but do you know what relevance means?
Certainly.
Yes. I'm simply saying, firstly, were you aware that the independent panel found that your evidence is irrelevant? And if so, are you surprised?
I'm not going to respond to that question because I didn't impose myself to this committee. They invited me, and I'm not even sure whether, that invitation was based on the work of, that independent panel.
Okay, well, it should be. All right, maybe let me put it this way. Do you think that any of your evidence is relevant to the work of this committee?
Yes.
All right. All right. You have explained the reasons for your disgruntlement with the Office of the Public Protector, correct?
Then disgruntlement.
Pardon?
Then disgruntlement.
Your previous disgruntlement, yes. Are you no longer disgruntled?
No, not at all.
Okay. When did you stop being disgruntled?
I was disgruntled probably for the first 2 days after I was dismissed. And then later on, I was no longer disgruntled.
I see. So you basically only became disgruntled after your so-called dismissal, not before.
When you talk about disgruntled, actually, I was concerned when I was there about, what was happening in the institution. And obviously, I was aggrieved when my employment was terminated in that manner. And yes. After then, I was no longer, aggrieved because I took a decision on how to challenge that.
Yes, no. I know that. I'm simply saying your disgruntlement or being aggrieved happened after what you call a dismissal, not before. Correct?
There's a difference between being disgruntled and having concerns and grievances that you could have, raised in there. So I think for me, I rather use the word, I had concerns around, other matters which I've raised with the office.
Yes. No, I think we're on the same side here, Ms. Baloyi. Your evidence is that you had concerns while you were there, but you were only disgruntled after your dismissal or aggrieved after your dismissal, correct?
What I'm trying to say to you, Advocate Mpofu, is when you use the word, disgruntled, I'm saying that when I was there, I was not disgruntled as such. I was just concerned. The only time where I was disgruntled was the first 2 days after my termination, which later on, as I said, I was no longer worried because I challenged, that decision.
Yes. No, then that's clear. No, that's what I was ascertaining. The only time you became disgruntled was after your dismissal. And I think you've answered my question. Thank you. All right. Now, you are aware that this is the impeachment proceedings for the public protector, correct?
Correct.
And not for Mr. Mahlangu, correct?
Correct.
Yes. And your major disgruntlements are with Mr. Mahlangu, correct?
No.
You have no disgruntlement with Mr. Mahlangu?
I do have, but I know Mr. Mahlangu was acting upon the instruction of the public protector. So, okay. So all these things that you've said about Mr. Mahlangu, you're saying they were upon the instructions of the public protector? I'm not saying per se all of them, but I know for a fact that, you know, some of the actions that he has taken, it was, you know, based on the instruction of the public protector.
Did you witness those instructions, or were you just guessing?
I'm not guessing, Advocate Mpofu. I said in my initial, testimony that even when Mr. Mahlangu gave me the letter, he said to me that, you know, he's also, you know, on his way out because he knows that the public protector is going to fire him. And also the second incident was when we're in the Eastern Cape discussing the Busasa issue in the presence of Ms. Mutsitsi. He actually stated that, you know, he is unhappy about some of the instructions that he's being given because of, you know, his at loggerheads with us. So I'm not guessing. It's matters that Mr. Mahlangu, you know, told me in the presence of other colleagues.
Told you that, sorry, I don't understand that. The fact that he was going to be fired, what does that got to do with what we're discussing now?
When he gave me the letter, you know, of termination, when I asked him that, you know, why do you actually give me letters that, you know, contain information that, you know, do not reflect the true reflection of my performance and the issues at hand in the presence of Mr. Gumbi. He said that, you know, I have to do this, and it's not like, you know, I enjoy doing it, but I'm acting under instruction.
I see. So all the basically then what you're saying is that Mr. Mahlangu was not to blame. He was just acting under instruction.
Depending on the circumstances. I mean, he was an accounting officer. She was an executive authority. That combination actually tells you the power, you know, of where the power resides in an institution.
I see. But you yourself never witnessed those instructions being given. So you did not
I witnessed them several times in our dashboard meetings.
Where the public protector said Mr. Mahlangu must do something to you.
Yes.
Right. Did she say that he must give you the letter of termination?
Not the letter of termination. The Audi letters that would be said in the presence of other, you know, colleagues who were reporting to me, in the presence of the deputy public protector when he attends those meetings, that, you know, must get those Audis. And you can, if we look at those minutes and recordings, you will find those decisions and those instructions.
Yes. No, I have no problem with Audi letters. Actually, as I've said before, I don't understand why Audi letters are weaponized as something negative. You know, Audi means the right to be heard, correct?
I think you could have heard me what I said about them earlier.
No, I'm asking you, please answer my questions, Ms. Baloyi. We don't have a lot of time. Do you know that Audi means the right to be heard?
True.
Yes. And do you know that the Audi alteram partem rule, which is the full term, is one of the rules of natural justice?
Yes.
And so you were saying there was an Audi environment, for example, you said that. In other words, there was an environment of obeying the rules of natural justice, correct?
It was not that. It was a tool that was used as a threat to me. I mean, having worked, you know, in many institutions with several people, I've never seen that. It was for the first time that I saw such an environment where you could even have, you know, a file of Audi letters.
Yes. Okay, it's going to assist if you just answer my questions, but I'll try. If you want to explain after answering, you are free to do so. But first, start by answering the question. The Audi letters were meant to give people an opportunity to explain why they had failed to do something, correct?
Not in this instance.
Oh, so the Audi letters were not Audi letters. They were not a right to explain why you failed to do X or Y.
I think if you look at my last letter that I received from Mr. Mahlangu, for me, the manner in which it was used, I'm not talking about the purpose of an Audi, but in this instance, they were used to build cases against certain people.
Right, okay, the evidence before you from several employees was that even those who were, as it were, critical of the public protector was that these letters were used as a means to give people a hearing, and if they gave sufficient explanations, then nothing would happen. I think Advocate Raidani and all sorts of people like that have confirmed that. So you're saying that they were not telling the truth.
I didn't say they didn't tell the truth, but for me, in a work environment, with the kind of issues that we were seized with, the question that I had is why, constructive engagements, not permitted, but rather, an Audi, is a norm, to grant people without even hearing them out, even if, that, room for that. It was a matter for me, that's what I'm saying. The purpose, I don't dispute it, but the manner in which, they happened and they were given, that's where, the challenge was.
Yeah, but okay. I don't want to spend too much time on this, but I'm just at sea of what you mean now. What do you mean what being given an Audi without being heard? I thought Audi was the opportunity to be heard.
I was given an Audi for, requesting Ms. Musana to withdraw her resignation, a matter that even today was never, discussed with me. Instead, it contained, wrong information. I'm talking about such things.
Yes, ma'am, but that's exactly what I'm like. Audi is like, if I say to you, Ms. Baloyi, why did you come late to this hearing today? And I give you an opportunity, and then you can say, no, I didn't come late. I was actually here on time, or I had load shedding or whatever. That's what Audi means. It means an opportunity for you to explain something. And if you explain it adequately, then we move on to the next thing, isn't it?
I think let's agree that it depends on the leadership style, with that Audi, and we can move forward. Advocate Mpofu.
No. We'll move forward when I say so. So I'm saying that you accept that the Audi letter is a positive thing, which is meant to give the recipient thereof an opportunity to explain what at face value might seem like a transgression. And it might turn out that there's nothing to it, and then we move on. You yourself received Audi letters, correct?
Yes, I received it. But I want to talk to you about the Musana matter. The Musana matter happened when the CEO and the PP were out of the country. Isn't it unusual that somebody that has been out of the country lands today and give you an Audi without even understanding the circumstances?
Yeah, but the Audi is meant for that person to understand the circumstances. That's what I'm trying to get into you. That's the whole point of an Audi. So if you come back from overseas or from Mars and someone says, Ms. Baloyi, while you were away in Mars, was beating up all the employees, then I give you an Audi letter and you say, no, it's not true, and that's it. Then we move on. That's the point of Audi, isn't it? To give you an opportunity to explain the allegation. And if the explanation is adequate, then that's the end of it.
We can deliberate on it or argue, but for me, it's my observation has been that it was just a tool that was used to instill fear, that people say that I've got an Audi after an Audi.
All right. Okay. In other words, all the people who were saying that this was an opportunity which was given to them, including Mr. Tebele, Mr. Advocate Raidani, and anyone else who received Audi letters, they were wrong.
I don't know if I can't comment on that because I don't even know Mr. Raidani. I've never worked with him. I'm not aware of Mr. Jelele's Audis because he was not reporting to me, so I won't be able to comment on that.
No. All right. Okay. All right, we'll come back to that. I need to, I'm not talking about the content of their Audis, I'm talking about the concept of giving somebody a right to be heard, but that's fine. In your case, none of the Audis ever translated into disciplinary action, correct?
Correct.
And that must be because you gave adequate explanations for whatever it is that was suspected to have gone wrong, correct?
No.
Then why were you not subjected to disciplinary action, do you think?
No, I never went through a disciplinary action, but those letters were ultimately used, for my final dismissal action. Because
yes.
when you look into the letters that, my final letter, you will realize that, it quotes all those Audi letters. So it was used, as a file, to finally get rid of me from the institution.
Right. And did you deliver on the issues that were raised in the Audi letters, ultimately?
Personally, I believe that I've delivered.
Yes, but the employer did not believe that you delivered, correct?
Yeah, the employer, that's their own opinion, but from my side is I viewed the matter differently.
Yes, no, that's fine. And in those situations, if the employer views the matter differently and you see it differently, which view should prevail? That your subjective view or that of the employer? In your experience.
You must remember that in terms of any other environment, an employer can never be aggrieved. An employer can never lodge a grievance. And the employer has got more resources and upper, hand over the employee. So even regardless of what you can do in this instance is, the question of what, the employer, has in terms of resources and authority. So at a time, even now, that the issues have been, put forward, but it depends on who actually is telling the truth. So I wouldn't stop them from doing any and other thing. They had all the resources, they had all the powers, they had all the authority to can do whatever that they wanted.
Okay, I also don't understand that. What you mean an employer can never be aggrieved? What happens if the employer is not satisfied with your performance or your conduct? Don't they, when they are aggrieved, institute disciplinary steps?
Which employer are we referring to?
Any employer in South Africa. Every day, when they are not happy about something, they institute disciplinary proceedings, don't they?
Depending on the circumstances, you can do whatever that you want. But somebody now, it depends on what is the policy of an organization, what your values are, what your leadership is, and what you want to achieve at the end of the day. And also if you allow room for development and probably allow room for, you know, for an organization to learn. What is a learning organization? That mistakes are allowed and whatever. But depending, if you want a perfect organization that, you know, you build a bridge, it must comply with all regulations at a go, depending, regardless of whether, you know, you just completed your degree. It depends on how you apply those kind of punitive measures and the circumstances, obviously.
Do you know of any employer in South Africa who does not have disciplinary, who doesn't take disciplinary measures?
You know for a fact, Advocate Mpofu, due to my level and experience, there won't be any other, you know, employer in this country who will take disciplinary action.
Exactly. So the answer is yes. Don't give us that long story. I was just saying employers, when they are not happy, they institute disciplinary action. Yes, that's it. We agree?
I can't say yes. I can't say yes that, you know, if an employer is not happy, it's not always the case that you implement a disciplinary matter. Because you're talking about happy. You're talking about happy. It's not always the case that, you know, when there's an issue, automatically take, you know, disciplinary action. You could be having various, you know, corrective measures that you can embark upon.
Just a pause before you come in, Advocate Mpofu.
Okay.
Honorable Jafta, you are disturbing the cross-examination. Please mute. Thank you. Proceed, Advocate Mpofu.
Yes. And you also know that the way to get performance out of employees is in basic management is the so-called carrot and the stick, correct?
No.
You don't know. Okay. Well, the only way to get people to perform, I mean, you can't put a gun on their head, is either to use disciplinary measures, or in the private sector, mostly also to use incentives, correct?
You missed one in the middle.
Yeah, let's just deal with the two that I've spoken about, then you can come with your third one. Are those two used generally? No.
No, not on performance, no.
Okay. So you've never heard of performance incentives or performance disincentives in HR theory?
No, I've heard them. But I'm saying that it's not a normal practice that, you know, an employer will implement those. When you look into the fact that performance in the public service, which, you know, especially in the public service, it's highly regulated on what you need to do.
Yes, but even in the public, whatever public or private service, the tool to get people to work is to put targets and enforce those targets. You can't beat them up. The days of slavery are gone. Would you agree?
Yeah, if they are achievable, they are realistic, and all the resources are there, and everybody else understands that it's possible to do them. Of course, yes.
Yes. And again, the evidence of previous witnesses called by the evidence leaders have been that the targets were intended to improve service delivery. And that was a good thing, wasn't it?
Not true.
All right. Now, and also the evidence of previous witnesses was that, and you may not have experienced this because you were only there for a short time, was that at a certain stage, the public protector basically, because people are not meeting their targets, even asked them to set their own targets. Did that happen while you were there, or maybe before you got there or after?
I'm not aware when you say that, you know, they set their own targets, because we are talking about people that could have had performance agreements.
Yeah, that's what an agreement is, ma'am. It's any one of the two parties to the agreement can make the suggestion. So it could be this side or that side. I'm saying that are you aware of the evidence that was given here that in certain instances, the public protector asked the employees to set their own targets?
I'm not aware of those kind of, concessions.
Yes. And you'd agree that that if that was the case, then that must have been an effort to make the targets reasonable. In other words, if you set your own target, you can't then turn around and say it's unreasonable when you didn't meet it, as a matter of logic. Do you agree?
I don't agree. I don't know the circumstances, so I'm not going to comment on those.
No, I'm not talking about circumstances, Ms. Baloyi. Please answer the question.
I'm answering the question. Yeah. I'm answering to the question. You are talking about the evidence of other people that I've never worked with and I've never heard about their issues. So I'm not going to agree to that.
Well,
because of the different, leadership styles and approaches were applied to different people. So I'm not going to agree to that.
Yeah.
Because I don't know.
Please listen. Do you mind, just if you listen to the question, it's going to help you. Relax, have a glass of water if you have water there, and just listen to the question. I'm saying, if you are my boss and you set a target for me, you say, Advocate Bofu, I want this next week, and then I don't deliver. Then you say, I want it a week later, then I don't deliver. Then you say, I want a week later, then I don't deliver. And then ultimately you say, okay, now set your own target. And I say, okay, I need 2 weeks. That's my target set by myself. And then I don't deliver. Would you agree that in that case, if the target was set by me, I cannot turn around and say it was unreasonable? Yes or no?
As I said, from a performance management point of view, it depends on many things. So I wouldn't actually say that, because for me is that you might not have achieved those targets because you got sick or you had other responsibilities in between. The circumstances in performance management do play a role as far as that is concerned, because of performance has got its own dependencies. So I wouldn't know that, what is it that could have happened. And if you haven't achieved, it is still my responsibility as your supervisor to ask, and to check before as to whether, the challenges that are there. So that's what I'm saying, that, performance has got its own dependencies.
No, okay, you're still not listening to the question. Please, ma'am, listen to the question carefully. Okay, I've said nothing about achievement of targets. I've said nothing about failure to achieve targets. Listen to my question carefully. I am saying only to you, if I set my own target, whether I'll achieve it or not is another matter. Would you agree that if I set it myself, I cannot say it's unreasonable because I set it myself? Full stop. Whether you forget about achieving it or whatever, all these long things that you're saying. Would you agree with that statement?
I've never come across it, so I would not say yes or no. I've never come across such, instances myself.
No, you don't have to come across it. I'm asking you as a human being who has a brain, who can just reason it out. If you are a leader of people, correct?
Correct.
You've been a DDG or working at that level for some time, correct?
Correct.
Yeah. Now, if in that capacity as a leader, if you ask people, you say, my management style is to ask you to set your own targets, and then they set their targets. Would you agree that those targets, those people who have set their own targets. This one can say, I'll take a month. Other one says, I'll take 2 months. Other one says, I'll take 2 weeks. After that, they cannot turn around and say those targets are unreasonable if they set them themselves as a matter of just at a logical level. You don't have to come across anybody. If that happens, would you agree that that would be a good way of setting targets?
Advocate Mpofu, I just take serious offense when you say that if I have to ask that question, I should be, a person with a brain.
No, I'm not saying you. I'm asking you, me. I'm asking you just at a logical level. That's what I mean. Anybody, like it could be. So the example I'm making could be happening at BP or ShopRite Checkers or whatever. It doesn't have to be someone that you have met. I'm saying if a leader at that place at BP then says to people, set your own targets, would you agree that those people are not entitled to then say those targets are unreasonable? Anyway, it could be in America or whatever. You don't have to meet anyone. I'm just asking you a statement of logic.
Sort of.
What is that? Is that a yes?
Not really a yes, but I'm saying that if it does happen, probably some way, because for me, it's any other employer, wouldn't say to employees, when do you want to work or how do you want to work and when do you think you can deliver and which kind of resources would you commit, to this kind of, an environment. All I know is that, target setting is an engagement process that, you will agree and then there'll be a role of the employee and the supervisor on what needs to happen. So for me, target setting is not something that, an employee decides. It's an engagement process.
Yes, an engagement process means both sides can come up with a proposal, correct? And then the other side agrees, right?
Yes, it's possible. Yes.
Yeah. So I'm only saying, so there can be 2 types then. The employer can come with a proposal and the employee agrees. Okay?
Yes, and it can be the other way around too. Yes.
Yes. Now I'm saying if it's the other way around, yes. If the proposal now comes from the employee and the employer agrees, you'd agree that then the employee cannot say it's unreasonable because it was their own proposal, correct?
Yes.
Thank you. Yeah. Okay, thanks. That's all I was asking. All right. Now, so the situation where you are saying you can't dispute because it might have happened in your absence that the public protector asked employees to set their own targets. That was the evidence of Mr. Tebele. You can't dispute that, correct?
Yeah, I can't comment. I've never worked directly with Mr. Tebele as my direct, reportee. So I can't comment on that. I don't know.
Yes, and therefore you can't dispute that, correct?
Yes, I can't dispute. I can't agree.
Thank you. Right. Now, the essence of your testimony really is that the public protector was very concerned about the backlog, correct?
Yes.
Yes, and that also has been confirmed by other witnesses. And she put systems, all what you and I have just discussed now, the targets, they were aimed primarily at trying to undo that backlog, which she was horrified to find such a big backlog when she got to that office. You are aware of that?
Yes.
Right. Now, you've used a negative word to describe this situation. And I just want to explore why, because you are saying other employees have said this was a good thing because it was about service delivery and concern about the complainants and the public out there. but you have put it in negative tones. You've said that the public protector, I think it's paragraph 9, you've said that at paragraph 10 of your statement, page 2568, that the public protector was obsessed with eradicating the backlog. So I just want to explore that loaded word there. What, did you mean that she was concerned or very keen to undo the backlog?
For me, it's, that backlog had to be done, by hook or crook, regardless of the circumstances, regardless of the fact that, some of these issues, have been clearly stated in the APP.
Yes, no, I'm saying, ma'am, it's a question of perspective. I'm saying the very same thing, depending on your own attitude, I suppose. Some employees have come here and said that this was a good thing, the relentless attack on the backlog, because it services the public. So that's their view. They have a positive view on it. You are putting it in negative terms to say it was an obsession. So I'm trying to explore whether the problem was with the project itself or with the point of view of whoever, the attitude of whoever was observing it. Yeah. So you accept that it was a good thing to attack the backlog, correct?
I stated earlier when Advocate Marise asked me the question that, eradicating backlog was in the interest of the public and also with the institution. But
so that's a yes. So that is a yes.
I've confirmed it to say yes.
Yeah, just to
It was not a bad thing, to eradicate the backlog. I've stated that earlier.
Yes. When I ask you a question and it just requires a yes or no, that will do, if you don't mind, okay? So it was a good thing.
Guide me. If it's a yes or a no, then it's fine. If you want me to say a yes or a no, guide me, then I'll respond.
Yeah, if it's wherever it's possible. And of course, you are free. I'm not stifling you. If I say, was it a good thing to attack the backlog? We can say, yes, it was a good thing. And then if you want to expand and explain, you can explain. Otherwise, we're going to be here all week. Do you understand?
Yes.
Thank you. Okay. So we're in agreement that it was a good thing to attack the backlog, yes?
Yes.
Right. And it is in the public interest to do so, correct?
Correct.
And the backlog, particularly cases that were older than 2 years, that was explained to you as your one of your key priorities, correct?
Correct.
Right. And when you arrived there, there was what you described as a massive backlog, correct?
Correct.
Right. And the massive backlog at the stage when you arrived was pitched at about 466 cases. Correct? And it is a fact that that was a moving target, correct? In other words, every month there'll be other cases that age. It's called age analysis. So if it was 466 at month 1, by the end of the month, it could have grown by another 50 cases that have just aged in that process, in that month, correct?
Correct.
And therefore, your estimation of 63% is misleading in that sense, correct?
No.
Okay, I'll break it down in small pieces. If you arrived there and the target was 466, by the time 6 months later, it could have been 1,000, correct?
Theoretically, what you are saying, it might have been the situation, but these cases, we're not working on numbers. We're working on the cases with a name. So we knew which case was registered when. So the customer services executive will record those cases. So there's no way that we can deal with Quinty and, then it's a moving target. We knew that there are these 10 cases that must be concluded by this particular period. Obviously, when you look into them, they wouldn't fall within the current financial year. So if you remember, what I stated earlier, I started in February, and by the end of March, we knew which cases needed to be concluded. So it was not going to be a moving target with all those cases per se. We had a way in which, all these cases were categorized very clearly, and we had a list of cases that will be 2 years, in 3 months, in 6 months, in actually even in 12 months. So we knew which cases, to deal with, because we had a very clear project plan and the names of the cases, and we knew that which cases, will be there and how they've been, that will be, would have been classified under that. So we had not the numbers, but the names of even the complainants. That's how we classified those cases.
Yes. Okay. Once again, ma'am, I'm going to appeal to you to please listen to the question. I thought age analysis is not something unique to the public protector. It happens in every organization, with whether it's debtors or whatever. It's called age analysis. You must be aware of that at your level, correct?
I'm listening, Advocate Mpofu.
No, that doesn't help us that you're listening. Either you say yes, or you don't know, or whatever. But my question is, do you know that age analysis by definition means that something, let's say you are managing debtors in an organization, or people who are not paying. So they say to you, there are 100 people who are not paying at the end of this month. At the end of next month, there will be new people who have now gone into the red, if you know what I mean. It's a moving target in that sense, that as every month, there are new cases that are aging. Do you understand that? Do you understand that, ma'am? I thought we had agreed on this, yeah. You and I had agreed before that it's a moving target because every month there are new cases that would be aging. So I don't know now what's the problem.
You said I must listen to you. I'm listening. I thought of your concern.
No, I never said you must listen to me. I said you must answer my question. I'm saying you and I had agreed that every month there'll be new cases that age and get into the category of 2 years. That follows as a matter of logic, okay? Correct?
As a matter of logic, correct.
Yes. Now, I'm therefore saying that if your job was to make sure that the backlog is cut down, there'd be no use in using a fixed target. In other words, to say, let's just use the 466 and then we resolve those 466, because if you resolve those in 6 months' time, by then there might be 1,000 other cases. So you have to approach this dynamically to make sure that the backlog as such is kept at proper levels. Isn't that correct?
Yes, but you'll agree with me that even if you manage debtors, you could use different methods and different models. So yes. There was no case that, could not be accounted for, for that particular period that I was there.
All right. Okay. I think, okay, I'll just move on.
Thank you.
You said that you, in the first 2 months, you achieved, or rather you dealt with 284 cases.
Yes.
You resolved 284 cases, correct?
Yes, yes.
Okay, so that would be something like 180 2 per month, correct?
I'm not sure the figures that you're talking about 182 per month because of I'm not sure whether you want to aggregate them, but I think the report is there on how what has been dealt with in that particular month.
Okay, actually, yeah, no, the figure is 142. I'm saying, well, it's a simple thing. If you divide 284 by 2 months, then you get 142. I'm saying that was the rate at which you were doing those cases, correct?
Correct.
Right. But there, after that, you resolved in the next 6 months, you resolved 83 cases. Correct?
Correct.
Which was now at the rate of 14, from 142 to almost a tenth of that, which is 14 cases per month. Can you explain why that happened?
Advocate Mpofu, the cases that we are dealing with here were the cases that when I started, it was my target, to finalize, the backlog. And what this statement means was that, of the 466 cases, 63 were finalized by the end of the financial year, and 83, in addition to those, were finalized in October. Those were the cases that were in the register, in the project plan that we're dealing with the backlog, then of the of that financial year.
Okay, I don't understand that answer. I'm saying to you, you were doing cases at the rate of 142 per month in the first 2 months. So on that, if you had maintained that rate, these cases would have been finished by April. So why did you then go down to a rate of 14 cases per month?
Those were the cases that were complicated, that needed thorough investigation, because it was not a case when we arrived at, for instance, when you arrive that it's a case that something has already been done. It was a case that nothing at all has even commenced with that kind of, a particular case. So it was not a simple case that, you would just deal with within, a week or whatever. So there were different kind of cases. There are cases that, in essence, even during that particular year, they were to be completed in 2 years.
Yes. Okay. So, okay, I think that's a better answer. Yeah. So you are saying then the 284 cases that you did were the easy cases, and the ones where you moved much slower were the more complicated cases. Is that the explanation?
Some of them, of those that were resolved, that is, some work has already commenced then, with those cases.
Good.
Yes, with some, of the 46 cases where that, nothing has been done at all.
Yes.
But the target that I had was I should have concluded them by the 31st of March, 2019.
All right. Now, you have testified that from around about April, there were already some disagreements that you were having with Mr. Mahlang, correct?
Correct.
And that would have been about 2 months into the job, correct?
Correct.
And this escalated. The high watermark would have been the July dashboard meeting that is now about almost on the 6 months, just before the 6 months mark, correct?
Correct.
Right. Now, but you believe that you were purged?
I don't believe that I was purged. I was purged.
Yes, but you yeah, that's what you believe. Yeah. The thing is, there are other people in the world who don't believe that you are purged. So I'm sure you'll allow that. That was your view, that you were purged. It has not been objectively determined by anyone else objectively. It's your subjective view, correct?
Much as what you are saying, Advocate Mpofu, I do not agree with you. There are people that could agree with me. So I do not believe that, if there are other people who believe that I was not purged, I'm not sure who are you talking about and on what particular basis. Because of the merits of my case have not been dealt with. So I'm not sure what is it that you want to talk about when you say few people. Who are we talking about here? And what are their interests? And where do they come from? Where do they live? So it's up to you. You will definitely believe that I was not purged because you are representing the person that purged me. So you are within your right, not to believe what I believe. But it depends on the interest of an individual.
Yes. No, I was not talking about myself. I'm saying that you believe that you are purged because that's what you have said in your affidavit, correct?
I said I was purged in my affidavit.
Yes. And you've read the other affidavit of the public protector that says you are not purged, correct?
Yeah.
Yes? Okay, good. So that's what I mean when I say you believe you are purged. So
no, I don't believe I was purged. I was purged. And she believes that she didn't purge me. So I do not agree with you. I was purged. For me, the manner in which, I have been treated and what I've been subjected to and the circumstances, I still stand that I was purged.
Ms. Baloyi, can you please assist us by just answering questions? Don't relax, ma'am. There's no...
I'm relaxed, but you cannot actually put words into my mouth and I agree with you. That's what I'm saying, that even in my affidavit, I've stated I have been purged. I didn't say I believe I have been purged. I state that I've been purged and she might believe that she didn't purge me. It's still within her rights.
No, but that's a lie, ma'am. You did not say that in your affidavit.
Which affidavit are we talking about now?
Which affidavit are you talking about?
I'm asking you because you're saying I'm lying and you are talking about my affidavit. The onus is upon you to prove to me by reflecting on what you are talking about.
Okay, which affidavit were you talking about?
I'm asking you which affidavit you are also referring to. Because now you have already indicated that I'm a liar.
Okay, can you go to paragraph 3 of your paragraph?
The affidavit on the screen, flighting it. So that the two of you can converge.
I didn't ask anyone to flight. I don't want anyone to flight things for me, Chairperson, please.
No, there's also a chairperson for the inquiry who do not need to be asked.
Yeah, but did you ask for it? Okay, ma'am, can you read paragraph 3 of that paragraph of that affidavit?
I make this affidavit to place before this inquiry the reasons why I believe that I was purged.
So which one is the truth? The one in your affidavit or the one you're saying here when you say you don't believe you are purged?
I beg yours?
You beg mine. I'm saying which one is the truth? The one that you said to the committee that you do not believe that you are purged, but you are purged, or the one in your statement where you say you believe that you are purged?
I was actually qualifying your statement, which says that, there are other people that, believe I was actually not purged. Because you said that's what I was qualifying in my argument with you.
No, ma'am. That's not how this started. I just said you believe that you are purged, and you said you don't believe you are purged, you are purged. That was before this thing about other people. Do you remember that?
No, you didn't say that, Advocate Mpofu.
I didn't
say that.
This questioning that we're having didn't start with me saying you believed you were purged.
You said to me, I believe that I've been paged and other
Yes.
people believe, otherwise.
No, I said that afterwards. I'm saying when I started this questioning, I said, ma'am, you believe you were paged. And you said, no, I do not believe I was paged, and went on and on and on. Then I said to you, there might be people who also don't believe that they were paged. Are you denying that that's what happened just here in front of everyone?
That's what I was asking you. Which affidavit are you referring to? Because my court affidavit is this one. The real reason that I was paged was because I was an obstacle. In this affidavit, I never said that, I believe I've been paged. So if you refer to the affidavit earlier, I would have said to you in my court affidavit, I have stated that I was paged. In the inquiry affidavit, I believe I was paged. So if you would have been open with me, I would have given you the answer that you were looking for, or we are looking for now.
Okay, I think you're giving false evidence to this committee, ma'am, and it's not a good thing. All you need to do is to accept that in your affidavit, you said you believed you were paged, and I was quoting that, but you were attacking me by saying, no, you were paged, you don't believe you were paged. That's the truth. So you don't, anyone who's listening to this who's neutral will realize that you're now just making it up as you go along.
Advocate Mbofo, I won't actually argue with you on what you said, but you said to me when you asked the question in your affidavit, when I asked you which affidavit, you can shake your head, but in my affidavit, that's what I was saying, that affidavit, I said I was paged. That's why if you told me that, you're referring to which affidavit, I could have told you.
But I asked you which affidavit you refer to, you refused to answer.
Why do you ask me a question when you called me a liar and I must actually help you to prove your point, whilst the onus was upon you to ask me which affidavit and am I referring to?
Chairperson, I think you should try to tell the witness to simply answer the questions, because this is, it's not necessary. She's now even misrepresenting my questions. Can you ask her to just answer the questions, Chairperson, truthfully, as she has sworn?
Advocate Mpofu, which question do you want to be answered?
All right, that's fine. No, it's fine, Chairperson. If you don't know, you don't know. All right. Okay. Ma'am, looks like not going to get any assistance from the chair, so I think we'll go this way. So
that was very nice.
let's start at the beginning.
Advocate Mpofu.
No, it's fine, Chair. I'll move on.
You have made a request to the chair so that the proceedings go according to what's expected. And I'm only asking you, what is it that you'd want me to insist on the witness?
Well, Chair, insist on her not to stop lying, because she just said, you were here when she said that she never said that she believed that she was paged. And now we've spent 10, 15 minutes on something that actually appears on her statement. And if we could carry on like this, we're never going to finish. So
okay. She's just referred to two affidavits and explained what each of those affidavits. And the one that is here in the inquiry is an affidavit where she says she believes she was paged. And the affidavit was placed in court. She said in that affidavit she said she was paged. So if you want her to confirm the version of this affidavit to this inquiry where she says she believes that she was paged, is that the question that you want me to put to her so that she confirms that?
No, I want you to, no, it's fine. It's fine, Chairperson. It's fine, leave it.
Ms. Baloyi?
It's a fine,
Ms. Baloyi.
Chairperson, please, let's move on, really. Ms. Baloyi?
Are you now
Yeah,
covered?
no, it's fine, Chairperson, sorry. I think
You
it will
won't
be
go back to this.
yeah, it will
thank
be
you.
a further waste of time, yeah. It's
Proceed, Advocate. Move.
Okay, Ms. Baloyi, I'm going to, at the end, I will demonstrate that your answers to this issue are complete fabrications and untruthful, and that you are just tailoring your evidence as you go along, because you've been caught in a lie. Do you have any comment?
You've made a statement, Chairperson. I don't think I need to respond to that because he is still going to ask me questions.
I've asked the question, ma'am, at the end. If you listen carefully, I have made the statement, then I ask a question. Do you have a comment? Question mark.
I don't have a comment. It's still within your rights to make those statements.
Thank you. Right. Now, you have said that you never raised these concerns when they arose in April, around about April 2019, correct?
Which concerns?
The concerns about what you call the constitutional transgressions within the Office of the Public Protector. You didn't raise them when you observed them first around about April 2019, correct?
I raised them. In one of the meetings, there's a recording when these issues were raised. I'm on record stating that I'm not an Idi Amin that is gonna actually crucify people, unfairly so. I'm on record in the Office of the Public Protector having said that in the meeting.
To who?
To the Public Protector, the Deputy Public Protector, the CEO and the executives were also in attendance of that particular meeting.
I see. Is that when you say you refused to carry out the instructions?
It was not that one.
When did you refuse to carry out instructions?
I never refused to carry out instructions.
No, but I thought, are you sure about that?
Which instructions, Advocate Mpofu, are you talking about?
Any instructions? Have you ever refused to carry out instructions?
If I refused, I wouldn't have lasted in that office. So I'm not aware of the instructions that you are talking about.
You never refused to take steps against employees when you were asked to do so. And you still lasted in the office.
But those are not instructions, it's an instruction.
Okay, so you refused one instruction.
I never refused, I was hesitant to take an instruction then. But finally, if you look at, the evidence that I've presented, finally, I actually implemented that.
Yeah, but at first you refused and you said you...
I never refused. I never refused. I never told anyone that, I'm not going to implement an instruction.
Yes, okay. Yeah, again, you are misleading the commission and you are being untruthful because that's what you said in your affidavit to the commission, to this committee.
That I refused?
Yes.
Which affidavit are you talking about?
I said the affidavit to this committee. You can't use that same trick again. It's the affidavit to the committee.
When you look at that, on many occasions, I would refuse to take such steps. I never said I refuse to take any instructions. There's a difference between what you are saying and what I've put, what you are talking about.
Yeah, well, it's worse than an instruction. It was pressure, isn't it?
That's your view. I wouldn't comment on it.
That's not my view, ma'am. And Chairperson?
Yes, Advocate Mpofu.
Can you tell whoever is putting those affidavits there, this is the second time and the last time I'm saying it, nobody must put any affidavit up there until I've asked for it. Okay?
No, you can't do that. No,
I
you
can.
can't do that.
I can. I'm the one who's doing the cross-examination.
No, Advocate Mpofu, this is a parliamentary inquiry and it has a chairperson who leads it and directs things. It is not your instructions that, and you even say it's going to be for the last time you do that. You can't do that.
It is.
Please refrain from that. Please refrain from that.
Chairperson, please listen to me.
I'm listening.
Yeah. When did you give the instruction to put up that affidavit?
Throughout this inquiry, when we refer to a paragraph that is under discussion or affidavit, it gets put up and it has assisted us a great deal so that everybody else follows where we are.
No. Okay. Let me tell you where we are. I will tell you where we are, Chairperson. How do you know where we are before I tell you where we are?
We're dealing with the paragraphs that you are examining.
No,
Miss Baloyi, let's not do a dialogue.
No,
that you're dealing with Ms. Baloyi
this is very important. This is very important. I don't want my
and I want to conclude, Advocate Mpofu, and I'm going to make a ruling. You can't do this. You can't do what you're doing.
What am I doing?
You cannot dictate to this inquiry what is it that we need to do, because we follow the cross-examination, the questions, because placed here is an affidavit that came to this inquiry, which is our primary source, and then there are other sources that in your cross-examinations are coming out. So if what would have been put there would have disturbed your train of thoughts, it's one thing to say that and say you would want to have the screen blank so that you focus on this and so, but you can't say it is your instruction that certain things must be up and not be up. It can't be. You came here by invitation with the public protector.
To be abused.
To the inquiry of Parliament.
Yeah, but I didn't come here to be abused, neither did she.
Nobody's abusing you. Nobody's abusing you. So please let us proceed. I would like you to proceed with the cross-examination. Please.
No, Chairperson, it's not going to be that easy. Listen to me. You have to listen. I've listened to you. This what I'm busy with now is called cross-examination. And I cannot, when I'm busy testing the credibility of a witness, I cannot have somebody else who's not in my team and who's not me putting up documents. It's not done, Chairperson. It's not done. You can't do this, not me. It's not done. It's just wrong. I'm sure you know that. You don't even have to be a lawyer to know that. You cannot, no, let me finish talking, man.
I think we're done with the issue. Thank you.
No, I'm not done. I'm not done. You might be done. I'm not done.
I want to recognize the members to come in. What is it that you still want to say?
Yes. No, I want to say this. I'm entitled to raise an objection, Chairperson. And you are also entitled to overrule the objection. But at the very least, you must hear what the objection is. And then you can come in. I've disagreed with almost all your rulings, but I've obeyed them. So let's just keep on working like that. Just hear me out. At least you can't gag me from talking. I'm saying that when cross-examination is being conducted in any forum, including this one, the person who is cross-examining is then in charge of the questioning. And it has never happened anywhere that before, when you're asking a question, testing the credibility of a witness on something, somebody else puts up the very issue that you are discussing. Because I could have been referring to something else, or it is seen as assisting the witness, which is not allowed to be done, Chairperson. Otherwise, this cross-examination is just a facade, or it's not cross-examination. It has never happened. It is not allowed, and I'm asking you to ask for it to be stopped. You, of course, have a right to say you don't want to do that. Then we move on. But I'm just trying to assist you in how these things are done. Thank you.
Thank you, Advocate Mpofu. Honorable Mulder.
Yes, thank you, Chairperson. Thank you, colleagues. I was under the impression that we are jointly trying to get to the truth, to understand exactly what happened. And in doing so, we need all the assistance we can get in terms of the different issues on the table. I didn't see being put on the screen anything that was not relevant to the issue that was being discussed or being cross-examined at that moment. So I find it very difficult to understand why, if Advocate Mpofu refers to a specific issue in the statement by the witness, that we as members of the committee are not allowed to see that paragraph and see exactly what is being said and what the argument is about. So I would like to request you, Chairperson, that in any case with regard to any witness, where reference is made to a specific issue or a specific paragraph or a specific statement in the affidavit of that witness, that it be shared with the members of the committee, that we can follow the argument, because in the end, I'm convinced we are all trying to get to the truth. Thank you, sir.
Thank you, Honorable Melder. Thank you for that. I'm ruling that we proceed now, Advocate Mpofu, and I will hand back over to you to proceed with cross-examination.
Yes, we will proceed, Chairperson, but I beg you to be just patient with me so that I can respond to what has just been said. We've been here, I don't know for how many weeks now, and I don't know why Mr. Mulder thinks that I need to be told that when statements are made, they are put up. I mean, surely by now he should know that that is what has been done. I'm raising a different point. I did not raise any specific issue to do with this, with that passage. I was simply cross-examining the witness, and I understand that Mr. Mulder does not understand cross-examination or how it works. And if he says it's difficult to understand for him, that's not my problem. His levels of comprehension have got nothing to do with me. I'm saying I'm trying to explain that why it might be difficult for him to understand. I'm saying that it is not done that a witness who's being questioned, particularly on a question of credibility, is then assisted by the other side, as it were, which is otherwise the cross-examination is not worth.
Thank you,
that, yeah. But I'm not answerable for the attitude or lecture of Dr. Mulder.
Yeah, just pause. Firstly, there's no other side. What is being shared here is an affidavit of the person, of the witness who's here. Honorable Mulder, I see you have your hand up again.
Yes, Chairperson, my apology. I just want to assist Advocate Mpofu as well.
I don't need your assistance. I don't need your assistance.
Advocate Mpofu, please. Honorable Mulder.
No, he must not patronize me. He must not patronize me. I'm not that kind of
Advocate Mpofu.
He can go and do that wherever he comes from. Not
the member is on the platform. I have not recognized you.
Yeah, but you must
I've
not
recognized the member.
Patronize me.
Advocate Mpofu, I'm asking you not to continue doing what you're doing. There's a member on the platform. There's a member on the platform that I have recognized.
I don't need his assistance.
Honorable Mulder.
Thank you, Chairperson. I'm trying to put some truth in this meeting. I do understand cross-examination as I am an admitted attorney of the High Court of South Africa until today. So I understand exactly what it's about, and I repeat my request that when we refer to statements of witnesses, that you please put that on the screen so that members can follow what the process is. Thank you, sir.
Thank you, Honorable Mulder. Advocate Mpofu, I'm asking you to proceed with cross-examination. Advocate Mpofu, I'm asking you to proceed with cross-examination. You are muted. You are muted.
Yes, I was saying, yeah, if he's an admitted attorney, that would explain why he's not a practicing attorney. And I want to know whether he has ever seen.
Thank you. Let's go to the cross-examination.
Sorry, Chair.
I'm still talking, Chairperson.
Advocate Mpofu.
Yeah, but
Advocate Mpofu, can you please go to the cross-examination? I'm not going to allow the dialogue between
but you can't interrupt me while I'm talking. You can't interrupt.
Please switch off your mic.
Yeah.
Advocate Mpofu, I'm asking you to proceed with the cross-examination.
No, Chairperson, no, relax. I'm going to continue with the cross-examination.
Proceed with your cross-examination, not a debate with members.
No, I'm not debating with any members. I'm addressing you. I am saying that Mr. Mulder or any other attorney in this country worth his salt will tell you that it never happens that when a witness is being cross-examined, somebody else puts up a document where the cross-examiner has not directed for that document to be put. Otherwise, he must go back to law school. Okay, now, Ms. Baloyi, you before that debate, you've said that on many occasions you refused to take steps that you were being pressurized to take, and yet before this you said you never said you refused. Which one is the truth?
Advocating both. When I drafted that affidavit that we are seeing in front of you that we are referring to, it was drafted by my attorney, Eric Mabuza, and it was presented in court by Advocate Mukaito. And with also the same thing with the other affidavit, I was assisted by attorneys. I'm not an attorney, but what I'm talking about is if you'd like, us to debate along those lines, and I think it's another, aspect. But what I'm saying is, I never said I refused instructions. I said to take certain steps. There's a difference between an instruction and implementing it, by taking certain steps. I never mentioned in that affidavit that I refused. I said I refused to take certain steps, not refusing instructions. And that's how I read and understand that affidavit.
Okay. And those steps were steps that were in respect of which pressure was being put on you by the public protector, correct? Correct, ma'am?
Not only through her, but also with the chief of staff and also with the CEO, yes.
Yes. Yes, so that's the point I was trying to make. I was saying, therefore, okay, I was saying, therefore, it's worse than an instruction. Pressure, an instruction could come in a non-pressurized way, correct?
I'm not sure what you are referring to. Maybe clarify what you want to ask me.
Yes. If I say, Ms. Baloyi, as your boss, I'm instructing you to please go and visit the KZN office. That's one thing. But if I'm putting pressure on you to do so, then it's worse than the first example, correct?
Maybe.
Now, if it is so, if therefore pressure is worse than an instruction, then you refused a pressurized instruction that's even worse than refusing a polite one, correct?
I refused to take certain steps, for instance, of charging people, for certain things that I believe that, that instruction, if challenged, it's unfair, to charge people for those issues. And another aspect is when I looked into the circumstances, I had to make an informed decision. So that statement is not talking about instructions, it's not talking about I refuse to take in certain steps. For instance, to charge, Ms. Mokhaladi, whilst, there are other, executive managers and provincial officers that are not meeting their targets and that actually are with other, executive managers. So I'm talking about such steps that, yes, as I stated earlier to you, Advocate Mpofu, and to put it in context, I've stated even in my affidavit inquiry that, there are certain measures that, could be applied where, the targets were not met. Than, yes, by immediately dismissing or charging people.
Okay. Who instructed you to charge Ms. Mokhaladi?
The public protector instructed me to charge Ms. Mokhaladi as well as the, the CEO.
Yes. And did you obey that instruction or did you disobey it?
As I stated on the James Wilson, issue, I actually did my work and I couldn't have charged her when the matter was closed in 2015. Okay, so you refused to follow that particular instruction? I didn't refuse. It was not worth it because it was not based on fact. It was inaccurate information that, that matter is outstanding and the matter was concluded in 2015. That, it's a matter that was dealt with by the public protector, the deputy public protector, and it's on record. And then I've charged her and end up with an egg on my face. For me, I had to check the veracity of that information, and so that, I satisfy myself that, it's worth charging her. And when I established the fact, we all agreed that there was no need to charge her.
Okay, so, all right. This has taken too long. What's your final word? Is that you did not refuse to take instructions or rather to implement instructions?
No, I never refused to implement an instruction. It's that I implemented it differently and still achieved the same results.
You never refused on many occasions to carry out instructions?
I never refused to carry an instruction. I refused to take certain steps that, I refused to carry instructions that to me came up, with unlawful action that I had to take.
I see. So you refused unlawful instructions?
I never refused. I never refused to carry an instruction. I refused to carry certain actions that came with that instructions.
Okay, what's the difference? You never refused to carry out when the PP had given you instructions to take certain steps?
No, I never refused. There was an instruction that, take appropriate action.
All right, can whoever was abusing my cross-examination now put up that paragraph 14?
At that point, we're going to take a 15-minute tea break and come back and will flight that paragraph.
Chair, can I just finish? So can I just finish this part? I beg you, just give me 1 minute so that I start on something else.
1 minute, okay. All right. Tsepo, just repeat the paragraph. Just repeat the paragraph.
Yes, paragraph 14, Chair.
Okay, 14.
Yeah.
There you go.
Now, okay, can you read from the beginning, Ms. Baloyi, and then maybe after the break, you'll try and reconcile your statement that you never refused instructions but steps. Start the PP's pressure. Can you read it aloud, ma'am?
You want me to read it?
I want you to read it, please. Yeah.
Thank you. The PP's pressure on me and other executives to take disciplinary measures against staff who reported to us was relentless. On many occasions, I would refuse to take such steps against staff members who reported to me after the PP had instructed me to do so, in circumstances where they had furnished me with reasonable explanations for their failure to perform the tasks at issue.
Okay, so this would be in circumstances where the PP had instructed you to do so. Is that what it says there?
Yes, I said where, I've been instructed to take, such action. A disciplinary action can be in many ways. And in my statement, it is very clear, Advocate Mpofu, that on many occasions, I would refuse to take such steps.
Thank you, ma'am. Yeah, thank you, Chair. We can go to the T now. Thank you, Chavez.
Thank you, colleagues. We pause for 15 minutes. We're back after 15 minutes to resume the cross-examination.
Chair, I'm here.
Thank you. Welcome back. Advocate Mpofu.
Thank you, Chairperson.
Please proceed.
Thank you, Chairperson. Ms. Baloyi, are you generally a dishonest person, or is it just today?
I will not respond to that question, Advocate Mpofu.
Okay. All right. Now, you've also been in management and leadership positions where the people were serving probation who reported to you, correct? Ma'am?
Correct.
All right. And you know that probation is not just about performance, but it's also about behavior and suitability in general, correct?
Correct.
And you'd agree that somebody who's dishonest would not normally be confirmed for a senior position in a place which needs fidelity, correct?
Depending on the circumstances of the organization, I'm not sure because of it. It depends on what is happening in that organization.
Okay. In which organization would you confirm someone who is dishonest? Well, depending on what?
I don't know any other organization that, if somebody has been dishonest to save the organization, probably depending on the values of that organization, you'll stay longer. In other organizations, which are reputable, dishonesty might not be seen in the interest, depending on the values. In some organizations, when you are dishonest, you can stay as long as your masters, are happy about it.
Oh, good. So have you ever heard of an organization that has as one of its values dishonesty?
I've never heard of a value, but I'm talking about if the leadership values and the leadership in that organization, are comfortable, with the people that are dishonest, as long as it serves their interests, they will stay.
They'll stay. Okay. Do you think in the public protector environment, you agree that, among other things, people deal with sensitive information and that confidentiality and dishonesty, or rather confidentiality and honesty should be some of the values that are paramount?
Correct.
Okay. Right. Now, you said that the public protector's leadership style was authoritarian, another negative word there. And you've also said that did you ever hear the public protector saying she must be called madam?
Yes.
To who?
I remember that, we were in a meeting and there was, an issue around, the behavior of, Cleo when I wanted to absorb her. And, that, she was being disrespectful.
I see. That Cleo, the one who called the public protector by her first name.
Correct.
I see. So it was in that context that she must either address her as by her surname or as madam or as the public protector.
Correct.
So why did you not say that she did not want to be addressed by her first name? Why do you put it? You said she's authoritarian and she must be addressed as madam. So you're portraying a completely different picture out of context.
Can I tell you my context of authoritarian?
No,
because it's not related to that. Then I can qualify my statement. If you want me to, I'll do that.
So the
But it's not related to Clio, that authoritarian. If you want me to clarify it, I can clarify it.
But the authoritarian is related to the allegation that she wanted to be called madam.
No, it's not related.
No, but it is, ma'am.
Isn't there? Can you please, reflect my statement so that I can look at it?
No, I'm not. I didn't say anything about the statement. Don't preempt me. I'm saying that your statement that she must be called madam is an explanation of why she's authoritarian. What do you mean it's not related?
The matters are not related, Advocate Mpofu.
Okay, then you can go to your statement. Go to paragraph 12. Did you write the statement, ma'am? You say the PP leadership style was authoritarian. She must be addressed as madam. Now you're saying the two things are not related.
I think between those statements, there's a full stop. Because of if there was a comma, they will be related in terms of how I understand it.
I see.
But actually, when you look into the, the second one, there's a comma, and they are related. So the two statements are not related.
Are you being serious now? Just because there's a full stop.
Advocate Mpofu, you asked me a question and I responded to it. And I said, if I read this statement, then I won't be able to respond to your question.
Ms. Baloyi, this is not a small game. This is an important issue about somebody's career. I'm saying, if anyone reading this statement, when you say the PP's leadership style was authoritarian, she must be addressed as madam. Those two things are clearly related, and they're intended to be related by whoever is writing that, putting those sentences next to each other, whether it's a comma or a full stop, is immaterial. What do you say to that?
My first language is not English, it's Tonga, and my writing is actually different, maybe from other people. And I am saying to you, the two statements are unrelated. You can read them differently, but I'm still saying that, the two statements are unrelated.
Yes, no, in any language, ma'am, whether it's Tonga or English or French or whatever, I'm saying that the statements are clearly meant to be related to the reader of that statement. Do you dispute that?
Yes, I dispute it.
Okay, I put it to you that once again you are being dishonest and untruthful and misleading this committee, and you are, I think, for the third time now, making yourself guilty of perjury.
We'll take it when this process is finished, but I cannot subject myself, to statements that I do not actually wrote. If that's your interpretation, unfortunately, I cannot do anything about it.
Who wrote this statement?
The evidence leaders assisted me. Yes.
Yeah. And the evidence that was given by Mr. Kelela was that the PP is referred to like that by everyone, PP. No, she's never insisted that everyone must call her madam. In fact, I think we have many emails from the likes of Mr. Kekana, which they say start as high PP and then go on to say whatever. That was the real culture, not the one that you're trying to portray, correct?
I don't know. I don't know, and I cannot comment because I've not seen what other people are saying. As I said, if I've seen it or I've heard it, then I will be ultimately be able to give you a definite answer.
Okay, so you've never, in the 8 months that you were there, or 9 months, you never had people addressing her as PP?
I've heard them talking about her as PP, and when she's not there, they'll call her Busi.
When she's not there, they'll call her what?
When they're not addressing her, talking about her, they'll call her Busi.
Yes, no, that's fine. I'm saying when she is there and they're addressing her in the meeting and dashboard or whatever, you've never had them calling her PP?
I've heard them, and I've also called her PP.
So the impression that you're trying to create by that statement is false. That she must be addressed. No, the impression that she must be, the word must, so she must be addressed as madam. In other words, she was insisting to be addressed as madam. That is false.
Why was Cleo actually removed from her office?
So you regard it the same, if someone calls, if you say, don't call me by my first name, to you, that's the same as saying you must address me as madam or sir or doctor or my lord or honorable or those kinds of colonial titles.
I'm 100% sure if that was not a serious act of misconduct, Cleo would still be her spokesperson.
No, ma'am. Please listen to me. You know that the case of Ms. Masana was that, firstly, she was not performing her duties, correct?
I'm not aware of that. And to date, as far as I'm concerned, I don't know about it.
Well, the evidence of Mr. Chalela is that there were 2 issues that were raised. One was not performing her work, and secondly was disrespecting the public protector. Are you disputing that?
I'm not aware because of when that happens, I was not in that office.
So therefore you cannot tell the committee as to what would have happened if it was the one issue and not the other. In other words, you can't say that if she had not called her by her first name, she would still be in that office, because it could have been the other issue was more important, correct?
I don't know, but if it was not important, you wouldn't have been measured.
Yes, that's what I'm saying. You don't know, correct?
I don't know, but all I'm saying is that if it was not important, it was not an issue. Having worked with Mr. Chelele, you wouldn't even have mentioned that.
Anyway, okay, let's move on. So I'm saying that's the 3rd or the 4th time that you are misleading the committee, because the statement that she must be addressed as madam is deliberately misleading now that we have looked at the context, correct?
No, I don't agree with you.
Okay. And then you said she must be bowed down to, quite literally. Who said you must bow down to her, literally?
Yes, the issue that, when she enters the room, we should all rise.
No, but rising and bowing down are the opposite actions. You said she must be bowed down to, quite literally. You know what to bow down is?
I know, I'm still talking. That is one aspect that I can tell you. The other aspect was when there was an incident where, we issued a report and a meeting was called later, and I was in a meeting which I believed it was a kangaroo court, whereby I've been asked to write an email to her and apologize. But I said the statement was not made by me, and we all had a responsibility. The spokesperson had a responsibility of, checking those kind of statements. And I was told that, this is what I need to do, because of, if I don't do that, because of you know that she prefers, people to apologize, all the time, and her character. And, that's what I ended up doing, on my last days, on that particular statement. And for me, that is a matter that, when you talk about being brought down to that, I could not take full responsibility of what happened. If really, as it's asserted in some papers that Mr. Mahlangu, was an accounting officer, she as an executive authority, whatever, but we could have looked into that particular statement. But, I was told that if I do not make that, because I know that she believes in that. And my interpretation was, if somebody has to be bowed down to, is that even if you are wrong, you also need to, even if you are not wrong, you need to ultimately do that, for her to not punish you. And I find, that incident being, irrational for me. And I was not even given an opportunity, to explain myself, but, I was actually told what is it that I need to do.
Okay, so that's what you mean. So this statement is not true then, that she must be bowed down quite literally. You know what literally means? It means she must be bowed down to, not in a figurative way, but in a literal way. So that's false, correct?
I do not agree.
Who said that the public protector must be bowed down?
It was Mahlangu.
He said that to you?
Yes.
What did he say?
He said to me, that if you don't do that, the public protector be bowed down to. And I said, but that is not right, because of, you also need to take accountability for. And he said to me, that if you don't actually do that, this matter, it's not going to be taken, lightly as you think.
What matter was that you were discussing?
It was a Mildred Oliphant matter.
And what were you supposed to bow down to?
Bow down to the fact that I take full responsibility of the media statement.
So you didn't actually have to bow, literally. You know what to bow is? You say you didn't write the statement. Do you know what it means to bow down?
You can educate me, Advocate Mpofu.
No, you can educate me. You're the one who wrote this. Do you know what bow down means? If you don't know, I can educate you. But first, you must tell me you don't know.
I know.
What is it?
It's bow down.
Yeah, how? What can you demonstrate to us? What do you do when you bow down?
So when you say that I must demonstrate, I'm not demonstrating the action, but I'm not demonstrating the action, but I demonstrate, what happened that actually would, lead to me bowing down to her.
All right. Anyway, all right. Now, the issue of probation. You were under probation in terms of, I think it's page 2200, Chairperson. Can you go there? You signed the contract of employment, correct?
Correct.
And you knew that your probation period was 6 months, correct?
Correct.
Now, before we get to the contract, can you explain if you are being, you said you believed you were purged, correct?
Correct.
Right. Now, if you were being purged for all these things that had happened since April, then why do you think that they did not simply just let you go at the end of July, sir?
That's for them to answer, because they didn't even today even communicated anything to me in July.
No, just hear me out. I'm saying, according to you, the disagreement started around about April, correct?
There were disagreements, not necessarily in April, but you know, what happened in April was amongst those. Yes, I hear you.
Okay, I'll take that as a yes. And they worsened, and one of the crescendos or the high watermarks was in the July dashboard meeting, correct?
Correct.
Yes, now I'm saying all this was before the end of the 6-month period for your probation, correct?
No.
I thought you said to Ms. Mayosi that your probation ended on the 1st of August or the 31st of July.
Yes, what I said was my probation could have been confirmed or not confirmed by end of July, but you know, most of the issues that happened, you know, beyond July also, you know, are issues that for me are way of concern.
No, leave the issues that happened beyond July. I'm talking to you only about the issues that happened before the end of July, okay?
Which issues are you referring to, Advocate Mpofu?
Let me start again. From around about April, the disagreement started, correct? Some of them.
Some of them.
Yes. And this escalated until, as I say, the crescendo or the peak of this also happened at the July dashboard meeting, correct?
The peak was not actually in July. I think it was after, you know, July, one of them, yes.
Okay, so you are changing that answer.
I'm not changing, you know, that answer, but I'm trying to tell you that, you know, during July, it was, you know, the peak, especially when we talk about July. I'm talking about the meeting of the 31st of July, which was the last day of July. It was not during July. And when you look into the issues that happened is, you know, you look at August, you know, you look at September and October, there have been various issues. Hence, you know, when you look at the final letter, it's talking about a lot of things that, you know, have happened and not necessarily before July or, you know, after July. So yes. if you want me to specify all those issues, I can, you know, gladly do so. So the July, it was when, you know, we got to know on the 31st of October how we were all viewed, including myself.
No, ma'am, please listen to my questions carefully. I know that there are issues that happened post the 1st of August. I'm not questioning you about those now. We will come to those. I'm confining my questioning to the issues that happened before the end of the probation period. Are you with me?
I'm listening, yes.
Yes. Now, I'm saying earlier, I know you've changed the answer. You agreed that it started after about 2 months and went on up until the 6-month mark, which was in July. Now, all I'm asking you is, if all these things had happened before the end of your probation period, then, and they wanted to purge you or to get rid of you or all the things that you are saying, then the simple thing they would have done is simply just not to confirm your appointment at the end of July. Then we wouldn't be here, correct?
If they knew what they were doing and what they were managing, probably they could have done it decently and correctly, so within the framework of the law, including their own internal policy.
No, remember, they're not doing it within the framework of the law. They are now busy purging you and victimizing you. So I'm saying, if they wanted to do that, they would have simply not extended your probation period on the 1st of August, correct?
Correct. Do you know that they even wanted to get rid of me before the end of July?
No, I didn't know that because you didn't put it in your statement. Is that a fact?
Exactly. It's water under the bridge now, but I'm putting it through to you that they wanted to get rid of me, before the end of July.
Good. That's even. Thank you. Then that makes it even worse. So they wanted to get rid of you before the end of July. So the simple thing then they would have done is just to tolerate you until the end of July and at the end of your probation, if they wanted to get rid of you, correct?
I like your word tolerant. In a public institution, people, instead of doing their work, they just tolerate me. All I'm saying to you is, in that kind of an institution, you expect people to do the right thing because we have even made findings against other state institutions for doing what they did to me.
No. Ms. Baloyi, do you even understand what I'm asking you? I'm saying, if these issues were culminating since April up to July, and you are adding to that, they even wanted to get rid of you before the end of July. I'm saying then come the end of July, which is the end of your probation period, then they would have just let you go and not extended it by any period or give you another chance or anything like that, correct?
Advocate both in a performance management, environment.
Yes,
even in when somebody is on probation, when you extend a probation, you inform that particular person. When you assess their performance, everything else is documented. There's proof that I, Vusi Mashangu, met with Basani Baloyi on this particular date, and this is what we agreed upon, and this is what she has not actually done, and these are the measures that we've agreed upon. So for me, it's, as I said, that if somebody has got, power and authority, you can do whatever that you want, but within the framework of performance management, there was a responsibility to do those things.
No, I agree with you 100%. But remember, here we're talking about people who want to get rid of you by hook or by crook, as you put it. So we don't expect them to do things necessarily by the law. I'm saying if they wanted to get rid of you by hook or by crook and by breaching the law, then all they needed to do was to wait for the 6 months and then simply not renew your probation, correct?
I don't know. I don't know. Really? I don't know. Anything was possible in that environment. I mean, on a monthly basis, then later, that's what I'm saying, that, initially putting it through to you, that when you work in that kind of an environment where you received, such threatening letters or notes, it actually, unsettles you. And at the end of the day, is that, in any other environment, you'll know that anything is possible anytime.
Right. And, but what they did here was actually to extend your probation, correct?
It was not extended, and Mr. Mashangu confirmed that it was not even extended. And even Mr. Gumbi, in our discussion with Mr. Mashangu, it was not extended. Because if it was extended, it would have been communicated. Because of it's even there in their policy that we are extending. So it was not an extension.
Okay. And so, but nothing was communicated to you, correct?
Nothing.
So also, if it was being confirmed, it would have been communicated, correct?
If it was confirmed, yes, it could have been communicated.
Yes,
like him.
That was not. Yeah. Sorry, ma'am. You can finish.
I'm saying, like him, when I was doing the Enquiry report, that I needed to finalize it so that he can be permanently appointed. Obviously, I would have, I knew that, that is the process in my own understanding that needed to be followed. So either way, it was not actually communicated to me. And when you look into the probationary policy and the disciplinary policy, my circumstances, required them to actually revoke some of the clauses in a disciplinary matter because they are talking about misconduct, which has not been communicated to me. They're talking about performance, which the probationary policy could have been invoked in terms of dealing with me, and none of those internal policies before we even look into legislation or the frameworks that govern, the two issues.
Yes, my question is much more simpler than that. You're saying come the 1st of August, nothing was communicated to you, correct?
Yes.
So the situation therefore could either be any one of the three possibilities, which is confirm, annul, or extend. You did not know which of the three it was, correct?
Well, what do you mean when you say I didn't know? Because for me, it's by the end of July, as per my employment contract, there should have been a communication to that effect.
Yes, no, I agree with you, Ms. Baloyi. I'm saying, okay, let's take it one step back. You asked, do you know that when it comes to probation, when the period ends, there are three possibilities. Either it will be confirmed, in other words, your employment is confirmed, or the probation will be annulled, in other words, you are terminated, or that it is extended. Those are the three possibilities. Nothing else can happen. Do you agree with that?
Correct.
Yes. Now, I'm simply saying to you, none of those three things were communicated to you at the end of July, correct?
Correct.
And therefore, you are saying it was not extended because nobody said to you it was being extended.
Nothing was done, not extended. Nothing was done.
Yes. None of the three things was done, correct?
Correct.
So it was not extended, it was not terminated, it was not confirmed.
Correct.
Right. Now, I'm saying therefore, then but your whole case was that your employment had been confirmed. So that cannot be correct. That's false, correct?
I never said in any case that, my employment has been confirmed.
Really? Well, that's what you said in the High Court case, at least that your contract by not saying anything to you, it meant that your contract has been confirmed. Are you denying that now? Ma'am, are you still with us?
I'm still with you. Can you actually display that and then so that we can see the context of what you're talking about? Okay. And I'll also, because of, don't talk to the, that statement in isolation of the probationary and disciplinary policy of the Office of the Public Protector.
No, that's exactly the policy I'm referring to. I'm saying that you and I have agreed that that policy envisages three possibilities, none of which actually happened.
But the policy does not happen in a vacuum. A policy needs to be executed. Yes. So whoever actually, approves that particular policy and the delegated authority to implement that particular policy.
Yes, no, on that we agree. But that's not what I'm asking you about. I'm simply saying that so you're saying it was not your case that your employment was confirmed.
No, I say that, put those documents so that I can look at them, and with those policies so that I can tell you the context of my statements.
Okay, I will do that, but I'm asking you a very simple question. What is your case? What happened after let's say on the 2nd of August? Were you working as a confirmed person, or was the probation extended?
Advocate Mpofu, we are talking about the Office of the Public Protector, which also deals with matters related to labor. I'll put it through to you, and my colleagues can attest to this. If it was another state institution that has done that, the public protector would have made a finding. So for me, it's why is she not actually complying with her own internal policy, knowing what, not doing that has got, knowing the implications of not communicating such a decision, much as you have stated earlier in your statement that you are dealing with somebody else's career. The same case should have been applied to mine, that, you are dealing with my career. So you'd ultimately be happy, to keep me in limbo. That was very much unfair. If really there were good intentions and she wanted to lead by example, she wouldn't have done that. She wouldn't have done that. And I can tell you, we have made findings even with other matters related to that. And some of them that, would ultimately ask institutions to implement. So I wouldn't sit in there and assume whatever, but what I'm saying is she had an obligation, to make a decision as per the employment contract that she signed with me.
Yes. No. That may well be so. But again, I was asking you a completely different issue. I'm saying that your case, all right, let me take you to the policy that you're talking about, or rather to the contract that you signed at 2200, please. Thank you. Okay, let's analyze that clause together. You signed this contract, you understood what it means, correct?
Correct.
All right. Okay. First sentence says you'll be on a 6-month probationary period commencing from the date of your appointment, and your probation may be extended for a period of not more than 12 months. You understand that part, eh?
Very well.
Okay, it does not prescribe the period of extension. It must just not be more than 12 months, correct?
Correct.
Right. And then, so it could be 8 months, it could be 2 weeks, it could be 2 days. It doesn't really matter, as long as it's not more than 12 months, correct?
Yeah.
Yeah. All right. Now, so that they said during this probationary period, your conduct and work performance will be regularly appraised in order to determine your suitability for the post. You understand that part as well?
Very well, very, very well on this one.
Okay.
That, my performance will be regularly appraised.
Yes.
I understand it very well, Advocate Mpofu.
Yes, ma'am. And then it says the employer may reasonably extend the probationary period and shall provide the employee with reasons for such extension and afford the employee an opportunity to make representation in this regard. Correct?
That is correct. And this is not applicable to the situation at hand with mine.
Yeah. Right. And then the 5.3 says, at the end of the probationary period, in other words, when it's ended, as I say, whether it's a month or 2 weeks or 3 weeks after the end date, The employer may terminate the employment relationship in accordance with the requirements of the LRA, Labor Relations Act, and the notice requirements in the Basic Conditions of Employment Act. Do you understand that?
Correct.
Right. So what seems to have happened here is simply that you were given an opportunity to show cause why the probation should not be terminated, correct?
Not terminated, confirmed.
No. You
Look
were
at my
given,
letter that is coming from Mr. Mahlangu. It doesn't talk about termination. It talks about confirmation.
okay, we'll do that. That would be at 20. That would be at 23. That letter talks about the first letter, ma'am, talks about the one of 8th, or rather the one that was signed with by the public protector, or where she inscribed, talks about non-confirmation. That's the same thing as termination. We agree?
No, that was after I responded. So we are talking about managing this particular process. That's a letter that informed me. I want us to go to the letter that informed me to make a representation. I'm not talking that letter, you know, inscribed by the public protector. That was my passport to go out of the premises. That was a termination letter.
The second one. All right, fine. Let's then take it step by step. The first one was for you to give reasons. It said that the PPSA has not been able to confirm your employment and considered it necessary to afford both yourself and PPSA an opportunity to continue assessing your performance and suitability for permanent employment in the position. In other words, to extend the probation.
No, I'm not talking about that letter, Advocate Mbofu.
But there's only one letter, ma'am. It's okay, go to...
No, there are 2 letters. There is a letter that asks me to, or requests me to make a representation.
Just a pause, Ms. Baloyi, Advocate Bauer.
I don't want us to have a big debate, Mr. Mpofu. Would it assist you if we flighted it?
No. The letter that you're talking about is you've said it was not the one where the PP made an inscription. So we can rule that out. That's not the one you're talking about, correct?
Yeah, that letter was a dismissal letter that the PP inscribed for.
Yes. Then putting that, there's only one other letter then that came from Mr. Mahlangu to you regarding this issue we're discussing, correct?
No, there are 2 letters.
Okay. Let's do it like this. Go to page 2338. You can flag that now. Yes. Okay. That's the first letter. It's addressed to you. And then if you go to...
Excuse me, Advocate, I wanted us to talk first about, you said the letter was talking about termination, and now we're looking at this letter, it's talking about confirmation.
Yes, I told you I was talking about the letter that with the inscription of the PP, but you're taking us to this one. I'm saying that's fine. I'm agreeing with you. Let's start with this one.
Okay.
Okay. Relax. Okay, so let's start with
Advocate Bauer, just a pause. Advocate Bauer.
The letter from the PP also says non-confirmation of permanent employment.
Yes, that's the one she calls a termination letter. We all the witness and I have agreed on that one, that it's about termination or non-confirmation, which is the same thing. Yeah. But her point is that this one does not talk about termination or non-confirmation, and I agree with her. So I'm saying let's start with the one where she wants to start, if you don't mind. Okay. Okay. So Ms. Baloyi, then we will walk through to the termination letter. So this letter, the first one is, let's call this the Audi letter. The letter where you are asked to make representations, right?
Correct.
Right. Now, in this letter of the 8th of October, it then says, invitation to make representation on confirmation of permanent employment. That's what you are referring to. Correct?
Yes.
Yes, as opposed to the one of non-confirmation. I understand
Yes,
that.
this is where, that's what I was talking about when I said to you, when you raised the question, and I was saying that, you know, it's, when you look at that first statement, which I had a problem with, and I still challenge it even today, how do you actually develop a policy and you still do not actually comply with that particular policy? And even when you are aware that you have not complied with your own policy, you decide to keep quiet. You don't communicate about that particular policy. And then 2 months later, then you want to talk about, as you are all aware, well aware, and it's not only being aware, but well aware, where I'm stating that you've got your own policy that you selectively decide which clauses or the content, to implement at a particular stage. And that's where I was talking about when you asked me the question that, was it actually, they could have done it, but I'm saying that it was intentionally done, because if, as you are all well aware, they were aware they are actually not complying with their own policies, and you still have got, the confidence, to put it on record that, you were aware, but still didn't want to comply with your own policy, and you didn't even, actually communicate that kind of a decision. So I wanted us to look at this letter so that we cleared it, that, it was not a matter that it was extended. It was a matter that they were aware that, my probation came to an end, and there was no, effort in terms of the policy, to deal with that particular matter. So that's what I wanted to talk to you about earlier.
Yes, ma'am. But this is their version. Okay, if you go to paragraph 3 of that letter, it says, as you are well aware, your probation period was supposed to expire on 1 August 2019. You understand that part, eh?
Yes.
Yes. Then they say, since then, however, PPSA has not been able to confirm your employment and considered it necessary to afford both yourself and the PPSA an opportunity to continue assessing your performance and suitability for permanent employment in the position of COO. You understand that?
I don't understand it, but it was a convenient statement, for them to can do that. They knew they wouldn't. They've never done that, to other, employees, but that was done specifically to me.
Yes. No, you might disagree with it, but do you understand what they're saying?
Sort of.
Yeah. All right. And then it says, it refers, I think you referred to this about the alleged misconduct that make representations why disciplinary action should not be taken, various Audi letters, copies, and so on. And it says, on numerous occasions, discuss your performance and impress upon you to conduct yourself in a manner that is befitting the role of a COO, and explain the importance of timeous delivery and quality expected deliverables. You understand that?
Yes, I can read it, and
Yeah.
I see it.
Yes. And then they say I'm jumping to paragraph 8. Your overall job performance, interpersonal relations, and general conduct has failed to meet the required standard and level of expertise from a person with your qualifications, expertise, and skills set as required and expected to occupy the position of COO. You understand that? You might, I know you disagree with it, but that's what they said to you, correct?
Yes, which is a lie.
Yeah, it's yeah, oh, yeah, all right. And then they said, in particular, but without necessarily being exhaustive of the issue, you continuously failed to deliver on the main target of 2-year and older cases. You have also failed to demonstrate an effective ability to adequately manage your direct subordinates and ensure the timeous delivery of quality work. Your compliance with rules and procedures in the organization is persistently problematic. You understand that, you disagree with it, it's a lie and so on, but you understand it, correct?
I don't even understand it because I don't even know what is persistently problematic. As I said, that whatever it's contained in this letter, you know, it's something that, you know, they didn't even deal it even within their own policy. If somebody at my level, you know, deal with issues of performance and discipline, they had all the rights, you know, to can charge me and communicate such, you know, and I say that you have also failed to demonstrate an effective ability to manage your direct subordinates. Which subordinates are you referring to? For me, this kind of a matter, you needed to state, you don't write such a vague letter when you deal with matters of discipline. A person needs to know at the end of the day, what is it that you are referring to? So you can see these are vague statements that ultimately, you know, suited the occasion.
Okay. And then they said, it is apparent that you do not apply the necessary tact, discretion, and adaptability in respect of the disclosure of confidential information obtained during the execution of your duties and functions and when communicating with staff members. In other words, they were saying you don't obey the confidentiality regime within the public protector, or you have breached it, correct? That's what they were saying. You don't agree with it, but you understand that's what they were saying, correct?
Yeah, they've stated it, and I still maintain that I don't believe with it. It was to suit the occasion.
Yes. And while we are on this question of confidentiality, when you went to court, you disclosed some information to the Mail and Guardian, correct?
Which Mail and Guardian? Which issue did I disclose to the Mail and Guardian?
The Mail and Guardian. Your court papers.
I disclosing to the Mail and Guardian to who? Because I was represented by a firm of attorneys, I don't even know. But let me put it through to you, also advocating both. That particular office, you know, had also a tendency, you know, to leak certain information to the public. So if you know, you say that, you know, I've leaked the information to the Mail and Guardian, I'll be very much interested, you know, to be provided with proof for such that, you know, needs to be, you know, presented by me.
I see. So you're suggesting that it was the Office of the Public Protector that leaked your court papers to the Mail and Guardian?
Probably, I don't know, because of they had that document. So why should it be me? You know, leaking, you know, the issues that has got something to do with my reputation, for whose benefit? It was the public protector herself that went on the news and said that I was a spy in that particular office.
Was that
and
before?
That I was sabotaging her, you know. So what that could have served me, you know, in terms of taking the matter to the Mail and Guardian.
Anyway, your response is at 2341, where you then ask for, you're saying that the deadline that you were given was unreasonable and you asked for an extension, correct?
Correct.
And then the response was a 2345, where Mr. Mahlangu gave you an extension up to Tuesday, the 15th of October, the following week, correct?
Correct.
Right. And then finally you did your representations, and that was submitted on the 15th of October, correct?
Correct.
And in those representations, you did not say anything about being purged, correct?
It was obvious that it was not necessary for me to do that because of, in my discussion during the handing over of the first letter, Mr. Mahlangu disclosed it to me. And it was in the presence of Mr. Gumbi. So for me, it was not necessary to disclose that.
So is that a no? In that letter, you did not say anything about being purged.
Yes, because I was not asked to respond to purging. I was asked to respond to, issues related to my confirmation of appointment. And, I had to respond to those paragraphs.
Yes, that's what I'm saying. So you then took the letter at face value and you responded to the merits of what you were being accused of. You did not say, no, I'm not going to respond to this because this is all just, I can't remember the word you used. This is just to suit the occasion. This is not the real issue. You responded to those issues that were raised, correct?
Yes, I responded.
Right. And the response that came at that point, therefore, you did not think you were being purged. You just thought that they were they were wrong on the allegations that they were making, correct?
There were a lot of things that were not right. So, yeah, that is the issue.
Yes. Right. Then the next letter was 2350. And in that letter, it was said that your representations have been considered and a decision has been taken. I'm sorry, if you can go, there's 2350. Yes, then it was said that the PPSA is of the view that you're not suitable. Sorry, go further down, paragraph 3, please. After careful consideration and the objective assessment of your performance, the PPSA is of the view that you are not suitable for the role of the Chief Operating Officer, taking into account, 1, your overall capability, your skills, performance, and general conduct in relation to the position. So that was the gist of why you are not being confirmed, correct?
I don't know. This was one of those statements that ultimately, they knew that if they put such, probably if you look at it at face value, you'll think that it's within, the law.
Yeah, no, I understand. But this letter now, for the first time after the communication up to now, is the first one that talks about non-confirmation of permanent employment. In other words, the termination or annulment of the probation, correct?
Yes, this was a letter that I even spoke about, that when you look at it, it's a letter that when you look at, it does not have ownership. For instance, the letter that I wrote, it was, I would have expected in terms of norms and standards that it would have read, for instance, in the second paragraph, to say that this letter, serves to confirm that I have considered, your representation and therefore the institution has taken such a decision. If you look at this letter, there is no ownership, in terms of the person that even responded. Then you ask yourself that where on earth have you seen this kind of a letter, in a public institution?
Well, you did not understand that the CEO was writing on behalf of PPSA, as he said. He did not believe it.
He did not believe it, and that he communicated to me when I was with Mr. Gombi, and that's why he wrote it like this, which shocked me, that you wouldn't write such a letter as an accounting officer. When you write it with authority, you write, your responsibilities, you write what you have considered, but it doesn't have even an I that I have considered 1, 2, 3, and 4. So he had to give me such a letter, and when you look at it, it says a story. It tells a story, Advocate Mpofu. It tells a big story.
Well, maybe I'm missing the story. I'm saying that the letter is clearly written on behalf of PPSA. Is that not good enough for you?
When I was appointed, the letter was not coming from the PPSA. It was coming from an individual with delegated authority. It didn't say that it does not even talk about, even when I signed the performance agreement, you can ultimately understand when you read the content that there's an individual, that wrote that letter. But this is a statement coming from such an institution.
But it comes from an individual called Mr. Vusi.
For instance, I'm saying, when you say that, who has considered it? When you talk about such things, you're not talking about an institution. If you were to benchmark this letter with other government departments, you wouldn't find, even in the West, kind of performing institutions, whether in a public institution, you'll never find such a letter. You'll never find such a letter.
Okay. Now, then the next letter was 2352. Okay. This one, it says, again, about your representations have been considered and so on. The only difference is that at the end of that letter, there is a handwritten inscription, correct?
Yes.
And a new paragraph 11, correct?
Correct.
Signed by the public protector, correct?
Which one are you talking about? We say
that's next to the numerical numbers 11. There's a signature of the public protector, correct?
Correct.
Yes. And this is now where you say then when you left Mr. Mahlangu's office, you bumped into the public protector, correct?
Correct.
And she obviously did not know what you had been discussing. She was actually surprised, correct?
She acted surprised.
Well, her evidence will be that she was indeed surprised. She's not. She doesn't have the ability to see what you and Mr. Mahlangu had been discussing. So she was. You explained what had happened, and she was surprised, correct?
I do not agree with you, and let's agree that we've got a different view on this one.
No, we do. I'm putting it to you that she was surprised. You are saying she was faking it. So we obviously don't agree.
There is a letter that she wrote to my attorneys of record. If you can go through that letter.
No, ma'am. We're going to
No, I do not agree, because if she was not aware, she wouldn't have written that letter. And yes, there are other things that for me, they're not necessary to talk about, but I can tell you that I've never seen it, even in any other institution, that you can dismiss a person at my level and nobody knows. And for such a crucial function, Advocate.
So you are Yes, she says she was surprised. You are saying she was faking the surprise. That's the situation.
Yes, she knew that was going to happen. I mean, when you say that she was surprised about my discussions with, with Mr. Mashango, I can tell you now, even where I work, there's no way that I can dismiss someone without even the executive authority, although, without knowing, even the accounting officer not knowing. But here we're talking about a COO that, is about to be terminated and the public protector does not know.
Okay.
I mean, really, even in our own houses, when you want to terminate a helper, your children will also know that tomorrow you'll have to make, your lunch boxes, prepare everything for your school and make sure that all is in order because tomorrow Ceci won't be here. But I'm saying that you want to tell me that she didn't know that, my employment was going to be terminated on that particular day and at that particular time.
No, I'm not telling you anything. I'm saying that according to you, you are saying that she faked surprise. And in that process of faking surprise, she even went as far as to put this handwritten. You asked her whether you would have an opportunity to appeal, correct?
I actually didn't ask her. I said to her, she didn't even have a decency of discussing with me the issues that Mahlangu is talking about. And as I stated earlier, that, we didn't even exchange that. I was not even given the letter throughout, whether it's the first or the last one with Mr. Mahlangu, but there was a discussion and Mr. Chelele was there. So yes. It was known what was happening. So I think for me, it's maybe the difference could have been that I live at, because the other challenge that when I spoke to her was, why do you want to chase me like a thief outside the building to say that I must leave now, as if, there is something at stake that I did not know. But probably, maybe the surprise was maybe I was leaving immediately after lunch, maybe instead of 4 o'clock, I don't know. But I put it to you, Advocate Mpofu, it's unprecedented in a public institution that, you can, even in any other institution, if really, you mean business about leadership and, culture in an organization, that, the executive authority in this instance, the PP did not know that, I was leaving on that particular day.
I see. So you're saying she might have been surprised by the fact that you had to leave immediately?
I don't know. I mean, like, for me, it's when I remember when we entered into, when I entered into Mr. Mahlangu's office, I mean, it was, we've just, dealt with this particular, and when I started to ask him questions is, I can tell you the culture in there, the way in which we do things, there was no way that, such a matter wouldn't have been known to the public protector.
Okay, and then, so she added the following, once you explained what was happening, she actually came to your assistance and added, should you wish to appeal this decision or make representation in respect of this letter, you can do so directly to the public protector within 5 days of the date of this letter. That's what she did. That was the action she took once you have, as you put it, confronted her, correct?
Yes, which ordinarily wouldn't have been done.
Yes, and in fact, it was just she was just extending a privilege to you, correct?
Is it a privilege? Is it a privilege for something that is actually in your policy?
Well, is there, in which policy does it say that you have an appeal in 5 days?
You can look at what the disciplinary policy is all about, because of here, it's not talking about performance. The confirmation of my probation speaks to issues of discipline and issues of probation. So you can look at both documents, and you can also look into the code of good practice.
I see.
That
So
means,
you're saying,
I mean, like, if it was, I mean, like, she didn't have to do it anyway. I'm not saying that she should have done it anyway.
that's what you're saying.
What I'm
That's what
saying,
I'm saying. It was a privilege, ma'am. Yeah, I'm saying she was extending a privilege. It was not something that was prescribed.
I don't agree with you.
It was prescribed where?
That's what I'm saying, that go to the disciplinary policy.
Yes, I've got it. And the probation policy, it says you have an appeal for 5 days. Is that what you're saying?
I'm not saying that, but what I'm saying is, I've never heard of such, if it's a privilege and she did not believe in it, it's very interesting. If you want to call it a privilege, we can move on. We can call it a privilege.
Okay, thank you, ma'am. All right. Now, so this person who then extends this privilege to you, you turned it down, basically. You did not want to exercise that privilege or right, as you call it, whichever one it is, correct?
After consultation with my lawyers, if you remember quite well, the letter to responding to this particular matter was coming from my attorneys, and it was after we looked at all the documents that, it will be just a waste of time. It's a foregone conclusion that, either way. And that was also informed by the letter that she wrote to my attorneys.
No, she did not write any letter to your attorneys first. Your attorneys wrote to her first, correct?
I can't remember, but it was also based on the content of her letter and the contents of, but at the end of the day is, after consideration of all the documents, I was advised not to ultimately, respond to that.
Yes, no, yeah, you can be advised, but you're the one who gives instructions to what the attorneys must do after they've advised you. So you instructed them that you did not want to take advantage of the opportunity to appeal, correct?
No, you're not correct. I'm saying that it's not me. And I don't think even in a situation today, you do what is best, in the interest of advocating Kwebani. And that's what, my lawyers did. It was in the best interest of my well-being, and that I don't even, consider responding to that.
Well, what was the reason that you gave them for not enjoying that right or privilege of the appeal?
I'm stating to you that we considered the matter and, the documentation and, from that point and the circumstances after that, if you do that, you want somebody to appeal and tomorrow you go out and make a media statement. Why? What makes you believe that, that person that has even gone to the media, will consider that objectively? At face value, it was just a waste of time.
I see. Well, okay. Your attorney said that you had told them that you will not be appealing because you said the CEO lacked authority. Is that a fact?
It was a fact because at the time, when you look into the minutes of one of our executive meetings, it was clearly stated in those minutes that, the delegations of authority, have not been approved. So he didn't have authority.
So that's why you told them that you won't appeal?
It was not only that, it was because of other matters, which I don't even believe that, they are necessary for this particular committee.
Do you agree that the only reason that was given by your attorneys was that you had told them that you will not be appealing or making any representations because the CEO lacked authority? Ma'am?
Yes, I agree with what is in that letter. Yes.
Right. And the public protector then responded and made it clear that on the day of the decision was communicated by the CO, you engaged her verbally and indicated that you wished to be afforded an opportunity to appeal and make certain representations. And she acceded to this, even though there was no legal or factual obligation to do so. You remember that?
I remember that.
And that they then said it was regrettable that you have reneged on your own request in that regard and instructed them not to exercise that appeal, correct?
Correct.
And then from there, you went to court and it was discovered you then, the High Court found that you did not have jurisdiction, and later on the Constitutional Court found that the matter should be remitted back to the High Court, correct?
Correct.
Right. Now, one of the issues that you raise, we don't have time to deal with all the issues that you've raised of the so-called, what you call the constitutional issues. But it was only, so your lawyers, when they wrote the letter to the public protector, they also did not say that you had been purged. They only raised this issue of authority, correct?
You mean that in all the letters, there was never a word purged?
No, it's not about words, ma'am. I'm saying in your letters that you had been writing, we have already established that you did not claim that there was something untoward, an ulterior motive. And I'm saying that in the letter from your attorneys also that was not stated. In other words, you did not confirm, they did not put as a reason why they were not, for example, appealing the issue of purging. It was not raised there. It was only the question of authority, correct?
Advocate Mpofu, as I stated that, the merits of this case were never even heard. So I'm not sure that, whether we're still going to raise it later on, when the merits of the case have been dealt with. So that's what I was asking, that whether you're talking about the word purged or whatever, but they know what, purging was. Well, they know that, I was actually purged. That's what I was saying, that the merits of the case have not been dealt with. And at the moment, I don't think we should be talking about, how they viewed this particular matter.
No, ma'am. I think you don't understand me. I'm saying, according to you, these shenanigans, alleged shenanigans, started in about April 2019, correct?
What do you mean by shenanigans?
I mean, when you said in 2019, you told Mr. Mahlangu not to get involved in the Inquiry matter and all that. That's when you had a disagreement, correct?
Yeah, I think probably we'll say disagreements, not really shenanigans, because I never put that word.
Yes. Okay. Let's call them disagreements. These disagreements started around April 2019, correct?
Yeah, they started showing around 2019, although there have been, drips and drabs,
Yes. And they continued up to July, the dashboard meeting in July, correct?
Not until. Is that,
Not until, up to.
It's not even up to, is that when on the 31st of July in particular, that's where, most of the issues were raised in a dashboard meeting.
Right. And I'm saying, and then in October, there's this process of confirmation, non-confirmation, and then your lawyers write the letter dated 28 October. This is now the end of October. I'm saying in all that time, up to the end of October, nobody has raised the issue of you being purged, not you and not your lawyers, correct?
I wouldn't understand why my lawyers would actually write about purging, in September, because they dealt with the matter after I've been terminated. So they wouldn't know what is happening internally.
Yes, but your lawyers, they don't know anything except if they are told by you. So I'm not blaming your lawyers, I'm blaming you. I'm saying up to that time, until the end of October, there was no mention by you or your lawyers of purging. That's just a fact.
The merits of this case have not been heard. Therefore, I cannot actually deal with those issues now. Maybe they'll still be, ventilated, in court if we go to court. So I do not understand, because as I stated earlier, the merits of this particular case have not been dealt with appropriately.
No, but the merits were raised in your affidavit, were they not?
But, I do not understand, because now you are asking me about the matters, that have been wisely advised by my attorneys, who are not even here to answer for, those issues as to how they came to that conclusion.
No, ma'am. I'm not asking about how anyone came to any conclusion. I'm asking you a very, very, very simple question. Up to this time, 28th October 2019, 6 months or 7 months since this purging process started, according to you, nobody mentions purging, ulterior motives, all these stories, the Enquiry, CR17, and all that. Nobody. That's all I'm saying. It's just a fact. It was not mentioned. It was mentioned or it was not mentioned.
It's not mentioned in those documents, but it was discussed in certain meetings.
Uh-huh. Okay, good. Then only in November then comes like a bolt in the blue, this affidavit making all these statements about ulterior motives. And it's signed by you on the 6th of November 2019. That is the first time that this is raised, correct?
No.
This was raised before with the Public Protector of South Africa or with anyone?
Yes, it was known, these issues. Hence, I'm saying that it is very interesting that from the beginning you said my testimony is irrelevant, to this particular case. But as I stated, that those issues were not new, and some of the issues were raised, in the office, and it was known. But when you go to court, obviously you're gonna write what you believe needs to be heard through the courts. So those issues were not ultimately, new to them. I mean, for instance, when I asked one of the questions why, I'm told about, my interpersonal relations and whatever, and I'm told that how I handled the Winnie Manyatela case, I said, but I didn't see anything wrong in whatever that I did. Interpersonal relationships with one person cannot actually build such, such a huge case to say that, general, I've got interpersonal relations with everyone.
Yes. Now, what has that got to do with the question I'm asking you? I'm saying that until November, nobody, not you, not your lawyers, had raised the allegations of ulterior motives or purging. That's just a fact.
But when you read my documents, I raised, the issue around, how Mahlangu dealt with the Enquiry matter, that, with the public protector. So it's not true that, some of those issues were not raised.
Yes, that was raised on the 6th of November, ma'am. That's what I'm trying to explain to you.
6th of
Until
November
that-
was not there. When you read my issues, the fact that when Mr. Mahlangu dealt with the Enquiry matter, I raised it with the public protector.
Ma'am, I'm talking about the termination of your probationary period. I'm saying until your statement you made on the 6th of November, signed by you before Commissioner of Oaths, that issue had not been raised anywhere in these documents or letters, correct?
Probably it was premature to raise it there.
Okay, good. So that's a yes. Okay, fine. Now, one of the issues you raise, you say that one of the so-called unconstitutionality is that the Busasa CR17 matter was rushed. You remember that?
Yes.
And you also say that the rogue unit matter was rushed, correct?
Not really rushed only, but there was information that we needed to consider.
No, but your real issue is that these two investigations were rushed, correct?
Can you please put through the affidavit where I say so?
Your affidavit, yes. Well, you say it in the affidavit here, but you also say it in the affidavit in court. Are you disputing that?
Just before you proceed, Advocate Mpofu,
Yes.
it's now 5:15. I'd want you to wrap up, please.
Yeah, no, Chair, I'm far from finishing now because the
time was set was 5 o'clock. It's 5:15 now. I'd like you by 5:30 to wrap up, please.
Yeah,
Please
no,
proceed.
then this witness will just have to come back here. Okay, go to page 2573, ma'am. Paragraph 20, we say, just as an example, investigations were rushed. Oh, sorry, not that. Investigations were rushed and the preparation of reports itself was also rushed. You remember saying that?
I'm saying that, Advocate Mpofu, can I see where I say that? Yes.
Okay, ma'am. All right. I think what's his name can help us. Tsepo, can you help us? Thank you. You see the part, investigations were rushed.
On this paragraph?
Yes.
I don't see Busasa here on this paragraph.
Ma'am, is it your view that the Busasa matter was rushed or not?
It is my view that it was actually, rushed.
So what are we debating then? Okay. Now, on the basis of your view that that investigation was rushed, and you base that on the fact that you're saying that invitation, rather investigation like that would take about 2 years. That's what you said, correct?
Where do I talk about IP here about taking 2 years?
Did you say, okay, it was rushed. How long was it supposed to take? the Bosasa investigation. Can you go to page 2173, please, operator? Yes. It says, you see that, you say, as I've noted earlier, these types of investigations usually take up to 2 years to finalize. You remember that?
Yes, which is commendable to finish it, earlier than 2 years, which I've stated, during my testimony when Advocate Mayosi asked me questions.
Yes, no, but you are not saying it's commendable. You are saying you are raising this as what you call unconstitutionality, and you are saying it's suspicious that it happened earlier, not commendable. It was suspicious according to you.
Where is the suspicious, Advocate Mpofu?
Did you regard it as suspicious? Don't ask me where, man. Just answer the question. Did you regard it as suspicious?
I'm not going to subject myself to that bullying that, you talk to me like that, unfortunately.
Just
I'm asking you a question that, is the suspicious? Yeah.
Did you regard it as suspicious, ma'am?
Those are words. I never said so.
Okay, read the next sentence. However,
this caused suspicions within staff members. I never spoke about myself. I spoke about the entire team.
Including you?
Including Mashangu, including Ms. Mutsitsi, including Mrs. Mukhaladi, including Madiba, when this letter actually. So yes, it was not a matter that, for instance, it's about me, but it was about, the discussions that we had in the office.
Yes, ma'am. And those people, they included you, Ms. Baloyi.
What do you mean when you say they included me?
You've just told us about the number of people who harbored that suspicion. I'm saying those people, they included you.
What do you mean they included me?
Which part don't you understand? The word include or the word me?
Both.
Did they include you or they did not include you? Include means you are one of those people, if you don't know. Were you one of the people who harbored the suspicion?
If it was me, actually, I would have stated in there, but I've given you an example in how, we dealt with this particular matter. So it's a matter that I said even to you earlier, that if this matter was given an opportunity, to be ventilated in court with regards to the merit of it, I should be able, to raise those issues. So here it does not talk about, it raised suspicions for me, but it talks about this caused suspicions within staff members.
I see. So basically you are just refusing to answer the question. Okay. Then the next issue was the message about you, which said that you I worked with a few people to deal with the sabotage of Pravin camp, and you're saying that you are worried about, it is not about you, but one has to play the chess. Is that what worried you? You now, not all the other members of the team?
No, I don't understand when you say the members of the team. Whom are you referring to?
No, I'm not referring. I'm referring to you. I'm saying what worried you was the issue that said it is not about you, but one has to play the chess. That worried you, Ms. Baloyi.
The whole message worried me. It's not about the latter part, but when you talk about the Pravin camp, which is the Pravin camp, when we are dealing with a matter constitutionally so. You are supposed to be looking at, the merits and the facts and the evidence before you. You don't need to deal with the sabotage, of camps. Okay. Because regardless, when you do an investigation, whether it's in labor relations at work, whether it's in a medical setting where you investigate death, or you do or somebody slipped in a shop, obviously you won't deal with a camp. You'll deal with, the merits of the case and the evidence before you.
So you must not, if people are trying to sabotage you or spreading lies about you and that investigation, which might jeopardize the investigation, you must not be concerned about that.
That's why when you do an investigation, you need, like whether you decide whether you want to be partial, whether you want to deal with the matter the way other people view you, or you want to emerge as a professional and do what is required of you without looking at secondary issues. Obviously, there's nobody that can be happy when they are investigated in any way. Yes. But at the end of the day, do you want to focus on those secondary issues, or you want to focus at the matter, at hand?
Does it matter if someone is trying to sabotage your investigation?
I'm not aware. I wouldn't see, unless if I'm not privy to that information that, maybe the sabotage, whether it's coming from the camp or it's coming from Praveen. I'm not privy to that sabotage information.
Okay, we'll come back to that. Your big issue with the Busasa investigation, you were saying that you wanted the public protector to investigate donations by Mr. Watson to the NDZ campaign. Correct?
I didn't say I wanted that investigation. I never said so. I said that it should have been mentioned in that particular, report, which has been excluded.
Yes, but you encouraged that the investigation must be extended to include the NDZ campaign.
Can I get side of where I said that?
No, you can't. I'm asking you whether you made a suggestion that the investigation should be extended to include the NDZ campaign. Yes or no?
Advocating both, I made a submission on this matter in writing in a memorandum, which the public protector had, and it doesn't have that content. I think if you can get side of that memorandum, then you will read what my concerns were and what my proposals were. So it wasn't about investigating the NDZ campaign. I've made it very clear on the issues that were omitted, in that report that, it was in front of me. And I was very professional in it, and I put them in writing. So it was not a matter that was only, expressed verbally or in court documents. There was a memo that, I prepared in that regard.
Did anybody suggest that the investigation must be extended to include the NDZ campaign, including yourself or excluding yourself?
When this matter came up, it was based on the Mail and Guardian, constitutional court judgment that, the public protector cannot ignore evidence that she comes across when investigating matters. And that's when, the issues of saying that we can mention it. And if you remember, I remember vividly that Madiba stated that it would even help in terms of dealing with the bill around donations, for political parties. So there was no malicious intentions around that. And, I made a submission in that regard with relating to that particular
Ms. Baloyi, please listen to the question, madam. I'm saying to you, did you encourage the investigator to extend the Cyril Ramaphosa CR17 investigation, Busasa, to include the NDZ campaign, to include those issues?
Which
yes
investigator are you talking about?
I don't know who the investigator was. I'm saying, did you encourage the investigator in that matter, the chief investigator, to extend the investigation to include NDZ? Yes or no? I mean, such a simple issue.
Why would I actually instruct an investigator when I've done my submission in writing on the matter?
I didn't say
because of he also had side.
No, I'm saying, did you encourage him or her to do so? Yes or no, madam?
For me, what I'm saying is I had a discussion, with colleagues.
Chairperson, can you please just ask the witness to answer the question, please? Did you or did you not encourage the investigator to extend the investigation to include the NDZ campaign, ma'am?
Yes. That's what I'm asking you, Advocate Mpofu. Where did you get that information? And if I've done that, it would be in writing on such a matter, given the statement that was made by Mr. Sekhalu. If really there was a matter on that, that's what I'm saying, that if I've stated in my affidavit, showed me where I stated it.
No, let's leave the affidavit for now. Did you, Ms. Baloyi, Ms. Basani Baloyi, yourself, did you encourage the investigator to include the NDZ campaign, to extend it? Yes or no? Forget about.
Why would the investigator that didn't want me to make input into his report, I encourage him or her when it was stated that I should not get involved in that particular matter, I must leave him alone. Yeah. Would you go under normal circumstances, advise someone who has already reported you to your seniors that, for instance, you would like to interfere with such? And hence I stated that, my contributions were made in writing. So why would I actually do that? Because it would be that, I'm actually interfering, with his work as it was alleged. So I wouldn't do that, and I mean, like, whatever that I did on this matter, if I recall well, Advocate Mpofu, I put it in writing.
So you deny that. Okay, that's fine. Now I'm saying...
I'm not actually, that's what I'm even asking you, who was the investigator that you're talking about? Because of clearly, even on that WhatsApp message, the public protector says that she has worked with other people. So I'm not sure which investigator you're talking about.
All right. Okay. You can then, maybe you can assist us. This is what you said. Okay, let's go to 2172, which is the opposite of what you're saying now. Another lie, another misrepresentation, another statement which you are seeking to disown. Paragraph 60 and on page 2172, please. Okay, you say, in light of these revelations, that is now the revelations that Mr. Watson had also given money to the NDZ campaign. Ms. Mokhaladi and I, that means you, Ms. Baloyi, encouraged the chief investigator to consider extending the scope of his investigation to include these allegations, or to limit the investigation to 500,000 to the 500,000, and to request the NBA to investigate the other allegations. Did that happen?
I don't see that statement that you're talking about to extend, the investigation to the NDZ campaign. It's not there in that statement.
No, I said, okay, which part? Extend or extending is the same thing, correct? It says, Ms. Mokhaladi and I encourage the chief investigator to consider extending the scope of his investigation to include these allegations. Which part don't you see?
I don't see NDZ. When you go to the previous paragraph of my affidavit, I stated that it's not talking about the NDZ campaign. He also spoke about donating to other political parties. So when you say that I encouraged him or her or them to consider the scope to include NDZ, it's not in my paragraph 60, Advocate Mpofu. That's what I'm talking to you about. And my paragraph 60 emanates from that last statement. So it's not only talking about the NDZ campaign. He also spoke about funding other political parties.
Yes, okay, ma'am, you're just lying to us again through your teeth. At paragraph 59, you say, Mr. Watson told the public protector that he donated not only to the CR17 campaign, but also to the NDZ campaign. That's you, not me. Okay, ma'am?
Continue and read the statement and read the latter part.
No, I will continue, madam. I'm just asking you whether, did you say that Mr. Watson told the public protector that he donated not only to the CR17, but also to the NDZ campaign?
Correctly, that's what he said. In the meeting, there's a recording on that meeting. That's what he said. And I think if my colleagues come in here who were present in that meeting, they'll confirm that.
Yes. And then you say, yet the public protector refused to investigate the allegations about donations to the NDZ campaign. Did you say that?
Yes.
Yes. Despite the fact that Mr. Watson indicated that there are many donors who fund political parties. And then you say, in light of these revelations by Mr. Watson, okay, Ms. Mokhalad and I encourage the chief investigator to consider extending the scope of the investigation to include these allegations. Which part is not true, is not clear to you there?
There's no part that is not clear in here, because of what I'm saying to you is you are talking about the NDZ, campaign. As I stated, when this matter, was regarded, it was a time that, as a collective, we believe that this will actually even assist Parliament, in terms of dealing with that particular bill. And we are also basing it on that Constitutional Court judgment. So it wasn't something amiss, because of we were saying that she was not, obviously at the time, the reason why that could not be investigated was because of the then Zuma as a person was not a member of cabinet, therefore that would be relevant. But we're talking about the information that was at our disposal regarding these matters. So it wasn't actually to say that we encourage him to extend the scope, to investigate. As you see in my paragraph 60, it was talking about these allegations that, were stated in a meeting, and it's on record, it's in the minutes, and it's actually there is an audio recording of this, meeting and these allegations.
Okay, but,
please wrap up.
Untruthful witness that has graced this committee. Chairperson, I still have some ground to cover. As you can see, the witness goes around and round and round in circles, but also there have been undue delays caused by the other unnecessary interruptions. So I need, there's quite, it's obvious that what we're dealing with here, but I still need to cover some of the issues. I never thought anybody could be worse than Mr. Samuel, but here we are. No, I'm saying, Mr.
Yes,
Chair,
please then wrap up.
Thank you, Chair. I'll try. But let me try, because as I say, I don't think really it's, I think the point has been made. So, ma'am, once again, you are lying to the committee. Once again, you are twisting the words, and once again, you are denying your own words. I don't know for how many times now. And as I say, you have earned yourself the title of the worst witness we have seen so far. So which is it? Is the truth that you did not encourage the chief investigator to extend the scope of the investigation, as you said earlier, or is the truth what is in your statement? Which one is the truth, which one is the lie? Because those two cannot sit together.
I'm not going to respond to that question. You've already labeled me a lie. Why would we seek more lies about the same matter from the same person? I'm not going to respond to that.
Chairperson, can you ask the witness to please respond to my question? Which one is the truth, ma'am, between you encouraging the chief investigator to extend, as stated in paragraph 60, under oath, or you saying to the committee earlier a few minutes ago under oath as well that you would not do such a thing? Which one is the truth?
That is an affidavit, or which I know. Paragraph 59 and 60, they are as they are. That's what they mean about what is in paragraph 59 and 60. It's what it is.
Is it the truth?
I'm not going to respond to that. All I'm saying to you is that if somebody deposed an affidavit, it's what it is. It's paragraph 59 and 60. That's the truth that is there. Whatever that you interpret and whatever that you label me, I cannot actually do anything to that. Okay. But what I'm telling you is 59 and 60, it's what it is.
Yes, ma'am. Okay, let's do it slowly. When you are doing 59 and 60, did you, as you did this morning, swear to God and say, so help me God, nothing but the truth?
You can ask my attorneys on that matter, because that was an affidavit that was filed in the High Court. So I think that we are not in court in here. So I think my attorneys are best positioned to respond to that.
Yes, no, we're not in court. So it's not the same thing, but there's only one God. So did you swear to God that it was the truth on that occasion?
I'm a member of the Evangelical Presbyterian Church in South Africa, and I believe in God. But whatever that we are looking for in paragraph 59 and 60, those contents are correct for me.
And they are the truth. So help you God.
You can interpret it in that manner, but all I'm telling you is that I am still stating that paragraph 59 and 60, those are the contents. If you require those details, you can speak to my attorneys of record. Thank you.
No, the attorneys of record did not actually they did not attest to the affidavit. Let's go to.
That will be our last point for the day, Advocate Mpofu.
Okay,
I've long wrap up.
Yeah, no, Chair, I have to wrap up this point because it's important. If you go to page 2160, do you know about perjury, ma'am? Do you know the crime of perjury?
I'm listening.
No, I know you're listening, but are you hearing? Do you know about the crime of perjury? If you don't know, I'll tell you what it is. It is lying under oath in connection with legal proceedings, and also the one that Ms. Ibrahim told you about this morning is also perjury. You understand that?
Yeah, you can do that. I mean, like the position that we are in now, if I was actually defending Advocate Enquiry, I will still say it. So that is your own conclusion. So you can say whatever that you want to say, but in paragraph 59 and 60 as is, I still stand by those issues, and I am not even gonna wink about it.
Yes. No, I don't think you can wink, but hopefully you can sleep at night. But so you don't know about perjury. All right. Paragraph 2 says the contents of this affidavit are true and correct and within my personal knowledge, unless the context indicates otherwise. And then at the last page, then you saw that this was the truth. Now, let me explain to you, because this is the last point I want to make for now. We'll see when we call you to finish your cross-examination. The point I'm making, ma'am, is very simple. I'm saying you made this statement, you said it was true, so help me God. This morning, you also saw and you said, so help me God. And in that statement and the statement you've made here, you have made several contradicting statements, so which cannot, which are irreconcilable and cannot be in the same boat. So, which means one of them is true, the other one is false. And you have refused to tell me which one is true and which one is false, but at least we know that one of them is false. So I'm simply saying that in doing so, under oath on both occasions, you are committing the crime of perjury. Do you understand? You might not agree, but do you understand what I'm saying to you?
Advocate both. Actually, I've come to this committee, to assist them in doing their work.
Yes.
And it will be up to them on, what to decide on whether my evidence or whatever. And I don't think it's actually your responsibility to make such conclusions. And I'm not going to respond to that question with due respect.
Okay. Then maybe you can respond to this question. Did you, as you said in your statement, encourage the chief investigator to extend the matter to include the NDZ campaign, or did you, as you said a few minutes before, not do such a thing? Which one is the truth?
Don't put words into my mouth. I said that this matter on this particular issue, it's very clear on 59 and 60, and to that effect, I even reduced my views and those of the team in writing and signed it off, so there is a record. So whether you want to talk about NDZ or you want to talk about other political parties, my paragraph 59 and 60 is very clear, according to me. And I believe that I was well represented by those attorneys, and I understood what they understood me and understood what that 59 and 60 is all about.
So if 59 and 60 are true, then what is false is what you said earlier to the committee, or is it vice versa?
It's up to the committee to assess that, not up to you. I'll hear it from the committee. Thank you.
Thank you, Ms. Baloyi. I'm not finished with you. I'm going to finish you later, and with the permission of the chairperson. But I just want to tell you that it is not assisting the committee to feed it with lies and to tell it untruths one way or the other. It's actually doing a disservice to the committee. But we'll deal with that when we meet again. Thank you.
Thank you, Advocate Mpofu. I now move to members to interact with the witness, and I will recognize members who wants to raise a few questions with the witness. Honorable Dlagude, followed by Honorable Gondwe, Honorable Mananiso, Honorable Sukas, Honorable Mailan, Dennis Wamkweba, am I missing anybody? Honorable Maneli. Thank you. In that order, members, we start with Honorable Dlagude, 1747. Honorable Dlagude.
Thank you very much, Honorable Chairperson. Good evening, colleagues, the PP and her team, our evidence leaders, and also Ms. Baloyi. Good evening. Ms. Baloyi, can you please explain to us your relationship with the PP when you first met her? Honorable Chair, am I audible?
Hello, yes, we can hear you now.
Yes, I asked Ms. Baloyi to explain to us her relationship with the PP.
When I first met her, it was a very good relationship. You know, we worked very well, and that's what I can say. When I first met her, it was a very good relationship, with no doubt, and we worked very well.
Then what changed then?
What changed was, for instance, when we discussed certain matters where we did not agree upon, and but what I would like to say is that it did not change from good. But you know, the issue is we did not agree on how to deal with certain matters.
Okay, thank you. Then in paragraph 5 of your affidavit, why do you think you were a barrier to the PP pursuing her personal agenda?
Firstly, when I dealt with certain matters, you know, for instance, I was not you know, well informed as to what could be the things that I should not do or the things that I should do. For instance, when I'll talk about a matter that when we dealt with the Mpumalanga, you know, matter, which was an Executive Ethics Act matter, which I discussed with the team. That is, it was all investigators in head office and all the provinces. We analyzed that report. When I finished that report, Mr. Mashango came to me and said that the PP is not happy that, you know, I have changed around that. But then when I went to the PP and explained that, you know, this cannot be an executive ethics, you know, matter. And she said she agreed, and the report was issued as such. But, you know, the challenge that I used to have is, you know, these issues were communicated to me in a very strange manner that, you know, for instance, when you want to deal with a matter, is the communication would ultimately be displayed as if, you know, the public protector does not trust me. And there are issues that I have done. For instance, when it talks about the disclosure of information, I got, you know, it as a complaint that, you know, I was at a funeral, you know, in Deep Kloof. I mean, like, it was just said I was at a funeral. And on that Saturday, I was at a funeral, you know, dealing with this particular matter. And then talking about social gatherings. Then my question was, why doesn't the PP talk to me if she's got issues around, you know, those? Because of, I spent even my weekends in the office, and I'm not even sure which social gatherings, you know, were being referred to.
Okay.
So those were the issues, yes.
Okay. What was this personal agenda that the PP was advancing in the Office of the Public Protector?
For me, it was to deal with matters, you know, not consistently with other, you know, dealing with reports, you know, some of them dealing with them, you know, in terms of our processes, but other reports, you know, were not dealt with, were dealt with differently.
Okay. Do you think she may have been influenced by external people to pursue certain agendas?
I am not sure what could have been, you know, certain people, because of, as I stated earlier, that, you know, when I got to understand that, you know, there are complaints about me, then the question that I had was that it can't be internally, because of I interact with colleagues on a daily basis, and I haven't come across such.
Okay. In paragraph 7, you indicate that the PP and the former CEO were driven by ulterior motives in the conduct when they conduct in the conduct of investigations. Can you please elaborate more on what these ulterior motives were?
For me, it was the first one, it was with Nkwinti. The issues that we had to do was to make a finding against Nkwinti, because the public protector, in her own words, indicated to me that we need to fast track that, that investigation, because of its dependent, on confirmation of the appointment of Mr. Mahlangu.
Okay. Considering the allegations you are making that the PP had an ulterior motive during investigations, did she approach matters with a preconceived and predetermined outcome in her mind, and therefore failed to be impartial in her investigations?
I would put it in this way, that, when we looked into the, the Pillay matter, which involved pensions, there was, a statement made by the then commissioner, Mr. Mahashule, that, it was said to be a cabinet decision, to appoint, Mr. Pillay. And I requested the investigator concerned, that then it was Njabulo, and we met with him with Ms. Mohaladi, and explained that, given the fact that, for instance, there's mention of the cabinet decision. Can you go and get, that cabinet decision throughout through the cabinet secretariat in the presidency, or through the treasurer? And the response that we got from the investigator, it was, that's a waste of time. We cannot do it, because of the public protector says we can proceed with this kind of an information. But I said, if there is a cabinet decision, why can't we actually verify all the information that were there? That is one example. Okay. The second example, it's what we dealt with when we dealt with, the case or a complaint against Minister Nxesi, and the matter was dealt with, by the Public Service Commission. And when I recommended that we cannot deal with the matter because of the Public Service Commission is dealing with it, and it's an employment matter. She insisted that, we need to deal with it because of, it needs to be finalized, an important matter. But with other matters that, involved other institutions where the Public Service Commission is investigating, wouldn't even, investigate such a labor matter. So I couldn't find any reason why we should deal with matters differently.
Okay. My last question, Honorable Chairperson. Considering that the CEO is not permitted to be involved in investigations, did you make the PP aware that it is not permitted for the CEO to involve himself in investigations? If so, what was her reaction? If not, why?
With regards to the CEO, is I found the institution to be like that the investigations will be concluded, and from the administrative side, I would be signing off that investigation report or deal with any other matter related to that, and then the public protector would do that. But in a case where, in question that you are talking about is when Mr. Mahlangu confronted me about the investigation that involved him, I actually raised it to the public protector, and her response was I should do my work. And she was aware of the issues that we were encountering in terms of finalizing that investigation.
Thank you, Ms. Baloyi. Thanks, Honorable Chair.
Thank you, Honorable Tlakude. Honorable Gondwe.
Thank you, Chair. Dumela Baloyi, can you hear me?
Yes.
Likai ma'am.
Rona re karaleng.
Re teng. I have a number of questions for you. You state in paragraph 9 of your affidavit that when you started with the Office of the Public Protector in 2019, there was a massive backlog of cases older than 2 years old. Would you attribute this backlog, massive backlog of cases, in this regard to the period prior to Advocate Mkhwebane assuming office in 2016? I'm asking this because we heard evidence from 1 or 2 witnesses that appeared before this committee to the effect that there was a considerable backlog of cases that could be attributed to Advocate Madonsela's tenure as public protector.
Thank you. That was it was a combination of her era and this particular, a tenure of advocating Mkhwebane. But it was, as I stated even before, that some of the cases were more than 2 years old. What we started, and these matters were not dealt with accordingly. But what was presented, during my period, mostly were the matters that that could have been done earlier than that, but mostly were within that particular period, or of Office of Advocate Mkhwebane.
All right, thank you. How would you describe the management and leadership style of Mr. Mahlangu? Would you describe him as Advocate Mkhwebane's enforcer? In other words, someone who would act on instructions without question?
Yes, he would do that. As I stated earlier, that in some instances, I would engage him about the approach in terms of dealing with matters. And as I stated, that at some stage he considered to me that anyway I need to act on an instruction, but I would say that, but you don't have information related to this particular matter. And let's engage, let's talk about it. Let me explain my side of the story. And then he'll indicate to me that I have to implement this instruction, unfortunately, and I'm not even proud to do so.
So did you get the impression that, he was afraid of her, or he was, reluctant to go against any instruction that she issued?
Correct.
You mentioned in the course of your, of your cross-examination by Advocate Mpofu that you knew that Mr. Mahlangu was acting on instructions of the public protector when he wrote that letter that eventually led to your dismissal. And at some point you mentioned, to this committee that Mr. Mahlangu indicated to you that he was also on his way out. So do you think he was forced to resign from his job as CEO, because he informed this committee that he resigned due to personal reasons, but he wouldn't really go into, the details around the reasons for his resignation?
I wouldn't know because he left, after I have left. So, but as I stated, he mentioned those concerns, not even once. As I stated, at the time I was with Mr. Gundi, and at some stage I was with Ms. Mutsitsi, that, he is really uncomfortable, about the environment.
In his evidence in chief, Mr. Mahlangu informed this committee that you were released from the Office of the Public Protector due to due to performance-related issues. And you informed this committee today in your evidence in chief that Mr. Mahlangu did not regularly appraise you on your conduct and work performance, despite your fixed-term contract requiring him to do so. Did Mr. Mahlangu ever make a comment in passing or informally about your performance being below expectations? You can go ahead and answer, ma'am.
Thank you. As I stated, I was never even appraised. Remember that even in my performance agreement, we couldn't even have used the cases only. There are other KPAs that are related, to my area of work. I was never even assessed, and I've never even had appointment meetings, that discuss my performance either with him or the Deputy Public Protector or the Public Protector.
So my question was, did he not mention anything in passing or informally that, Ms. Baloyi, I'm not happy with your performance?
No, because he wouldn't have pronounced on that because he was not involved in investigations.
Okay, so you were obviously taken by surprise when your appointment was not confirmed and you were ultimately dismissed from the Office of the Public Protector.
Correct.
All right. The letter that the committee was shown today that was written to you by Mr. Mahlangu made reference to a number of Audi and reprimand letters being sent to you. How many Audi and reprimand letters were sent to you? And please confirm if all these letters were sent to you by Mr. Mahlangu and what some of them related to.
Yes, the letters were written by Mr. Mahlangu. It would refer to matters, related to not completing the cases on time, regardless of what I could have explained. I also received an Audi, if I recall, around the issue of Ms. Musana, around that. And I also received another Audi. I remember that there was a sort of a church that was organized, that we supported the PP. And when I come back, then I got a letter that I could have submitted those reports, although I agreed with Mr. Mahlangu that I'll give them to him the following day. So I can't recall all of them, but I had few of those. That's what I even stated, that they could refer to them. But mostly it was around, when we go to the dashboard meeting, you have not met your targets, then you'll get an Audi. Or, it was mostly around it, that every other issue that, that probably you can look at, you'll just give you an Audi.
And please confirm if these Audi and reprimand letters, in your view, were issued, via the instructions by, Advocate Mkhubane, or whether you feel she had knowledge of them.
She had knowledge of them because when I spoke to him around the issue of Musana, he indicated to me that, my conduct was undermining the authority of the Public Protector, which to my surprise was, they were both out of the country and, there was no acting Public Protector and there was no acting CEO. And at the time, I was the most senior that could have explained this whole issue. And taking into account that Ms. Musana was willing to go, at that stage. And I didn't even ask the Public Protector why, the matter was given like that, but it was an Audi that was related to the fact that I shouldn't have done it and that I've caused the institution, reputable damage because of Ms. Musana has lodged this matter in the CCMA. And to date, I think I've been exonerated because of the constructive dismissal matter. It was not caused by me. It was actually part of the contents of Ms. Musana's resignation, a case which she won at the CCMA, and she also won, the appeal of that matter.
Thank you. You mentioned in the course of your evidence in chief that you had also issued, Audi letters to people that were reporting to you. Please confirm to this committee under what circumstances Audi letters will be issued to an employee in the Office of the Public Protector. And to your knowledge, what steps would precede the issuing of an Audi letter? I'm asking this because we heard from Advocate Mkhwabane's counsel that a number of steps preceded the issuing of an Audi letter. And we also heard that an Audi letter was not necessarily a warning letter, but given prior to a warning letter.
it was very difficult an environment to work in. For instance, the reports that, were older than 2 years, it did not mean specifically that, the executive managers were investigating them. Below that level, the cases were investigated by chief investigators, senior investigators, and other investigators. And when you look into that work, that's how we got to the conclusion, of some of the work that were happening. So, when you have not achieved, I've given, the Audi letters, and the instruction was very clear that you give those Audi letters and you must provide proof that, you have dealt with them, regardless of the fact that you could have explained what is the challenge, but, you would have even, given somebody an Audi, for not having met the target. And in some instances, you'll find that the reasons, around that, missing that deadline, they were sound in terms of what one could have received. So, yes, I have, given those Audi letters, and I wouldn't even understand why we start with the Audi rather than dealing with an issue, because for me, I was also of the view that, we needed to apply our mind and look into all the factors that contribute towards that.
So what were the steps preceding that, the issuing of an Audi letter? Would there be a verbal warning?
No, there was nothing.
So it was just issued, at whim?
Yes, you'll get one, one Audi after the other, even if the issues are the same, that naturally, when you give an Audi and, the issues are unrelated, yes. But, in some issues is that, it will be the Audi around the, the same matters of not meeting the deadlines, of all those cases 2 years and older.
Thank you. In your affidavit, you make reference to there being a culture of victimization, fear, intimidation, and disrespect under the leadership of Advocate Mkhwebane in the Office of the Public Protector. Other than Mr. Mahlangu and Advocate Mkhwebane, in your opinion, who else in the Office of the Public Protector was also directly responsible for perpetuating this culture of victimization, fear, and intimidation?
It was the Chief of Staff.
Please, can you state the name of the Chief of Staff?
It's the late Mr. Nyembe. He will do that, to us.
What exactly would Mr. Nyembe do?
He will ultimately, utter statements. For instance, when we're explaining that, for instance, this particular employee could not meet the deadlines, we are also helping them. And instead of looking at that, he will talk about how much we are earning and why would we come to the meeting and not having concluded certain matters, and what is it that we actually do, on a daily basis when we come to the office, which to me, it was a matter stating that, for instance, we are just irresponsible individuals who do not want to work.
Chairperson.
It will be your last point when I come back to you. Advocate Mbofu?
Yes, no, Chairperson, I just wanted to register an objection to that kind of question, which is both unfair, irrelevant to what is being investigated here, but also insensitive. Mr. Nyembe cannot answer for himself, and he should not be subjected to a witness of this nature who can say anything about him. Please, let's be respectful to those who have departed.
Thank you, Advocate Mbofu. I've noted your objection. Thank you. Please, Honorable Gondwe, that's your last point.
Yes. Baloyi. Baloyi?
Yes, I can hear you.
I have another question around this culture that was perpetuated of victimization, fear, and intimidation. Was there anybody else outside of the Office of the Public Protector that you felt contributed, towards the perpetuation of this culture?
I am not aware of any, external influence that were there, because of mostly one was seized with doing the work. There could be, but I'm not aware.
Thank you.
Thank you, Honorable Konda. Honorable Monanis.
Thank you, Honorable Chair. Greetings to members in the House and as well on visual platform. And let me welcome you, Baloyi, okay?
Good day, Guy.
Good day, ma. It's you seem to be angry about what happened to you when your probationary period was not confirmed. I want to check with you, ma'am. Are you here to settle a score with the PP considering how you were treated?
I'm not angry. And it's not, I've gone through a lot of things that I could have suspected that, that office is behind what I was subjected to, when I left that particular office. And I appreciate being here today. I don't have any scores, to settle, because of when I looked into the matters that, that I have testified on. It's issues that not only me, but I am doing it to assist the committee to do its work, number one. Number two, there are people that are sitting in that office who didn't like to talk about it. Number three, there are employees that have left, that institution. And because of that, there are also employees that have died that today could have loved, to talk the truth. So I've got no score to settle with Advocate Mkhwebane. I've come to terms, as I stated earlier, that, there is nothing that I can do, whatever that she did to me. So either way, it's something that I'm doing out of my own will. And I hope that after this process, that office would be different, that, it will change the culture that is there, and address some of the issues. So I'm not aggrieved, and I don't have a score to settle with her at all.
Okay, thank you, ma'am. And then my second question to you is with regards to the issue of security clearance. Other people came before us and indicated that some members had the security clearance and some didn't. For specific, Mr. Fuzi Mahlangu didn't have the security clearance. So I want to check with you. Do you think that the public protector was treating Mr. Mahlangu differently from any other members?
With regards to the security clearance matter, in terms of Mr. Mahlangu, I mean, the first time I heard that, he did not have security clearance, it was when, I read it in the paper. So I was not aware that, he does not have, security clearance myself, because it was a matter that, was in the jurisdiction of the Human Resources Unit.
Okay, on paragraph 13 of your affidavit, you indicate that the PP did not provide employees space to do their professional work. Did this have an adverse effect on the morale of the staff in any way?
Yes, because of, as I stated, I would give an example that, there were, employees that, were not happy around how we, dealt with certain matters and, created tension between, for instance, I'll talk about, with certain investigations, I had to deal with Mrs. Mohaladi, Advocate Madiba, and Koch, around the investigations. So, in most instances, you'll come across that, and in some instances whereby, with some employees, the investigation has been, moved away from one employee to the next, which also delayed. And, when you look into the environment itself, most of the of some of the investigators, when we address them, for instance, they'll say that, there must be a clear line. There must be my investigator, your investigator, and the PP or whatever, because of, some of these issues that you guys are changing, really we are not happy with. So those are the kind of issues that, we had, in that particular office.
Okay. Was there anything wrong with the PP involving herself in operational matters? As she is the head of the institution and the executive authority accountable to Parliament for what happens in the organization, would you say her involvement in operational matters was a deviation from the standard of behavior expected from an executive authority?
For me, it's when you've got an executive authority with such junior, with such senior officials, there are certain matters that, could have been delegated to be dealt with by, executive managers because of, they are there and they're doing, their work and they're being paid for being at that particular level. But what I can say is it also depends on your leadership style. What is it that you want to do, and with some matters I could agree, but with some matters, really it was not giving executive managers, to do their work that you could even wholly get them accountable for that particular, failure or that particular non-performance, if you may call it, or for such challenges not being addressed quite well. So at times we'd find ourselves, with competing views in terms of resolving those particular matters. But again, it's a matter of, choice, even if it's not a political institution, but that level, obviously, it was supposed to be clear as to what are the issues that we needed to be dealt with and the issues that, that office cannot deal with at that matter. But, if they are escalated to that level, yes, they could be dealt with.
Yes, lastly, Mama Baloyi, my question is with regards to what you have narrated on your affidavit, paragraph 12, when you speak about the leadership style of the PP. I just want to check with you, did the hairstyle actually affect the OPP negatively?
Yes, it did. I would give you an example. When we wanted to deal with when there was a relationship issue in the Gauteng office, as I stated earlier, is that the issues could have been raised with the executive manager to address them. But the issues were raised with the CEO and with the public protector. And in that particular space, in terms of addressing some of the matters, I was excluded in terms of trying to get those kind of issues being addressed, which created tension, amongst, employees as to, who is responsible and for what and who accounts to who. So in any other organization, when you find things like that, they affect morale. They, because of governance structures also, becomes an issue in terms of, taking accountability. So we would find that in that particular office.
Okay. Chairperson, as I learned, I just want to, as a follow-up to the question that I've just asked, do you think her conduct falls short of the standard expected of a public office bearer, ma'am? As I conclude, thank you.
I wouldn't say it in that manner, but I think she could have done better, in terms of addressing issues in that office, given, its mandate and the fact that, we could find other executive authorities, other accounting officers, and chairpersons of board in public institutions, for the similar, issues that are actually happening in that institution.
Thank you, Ms. Baloyi. I now recognize Honorable Sukas. Honorable Mari Sukas.
Thank you, Chair. Mrs. Baloyi, thank you for presenting yourself to this committee. It is appreciated. I have a few questions for you. I will start with the first one. Do you know who took the decision to introduce Audi letters?
I do not know. I found it there.
And can you explain what written directives were given to line managers on how and when to use Audi letters, and where can we find those perhaps as a committee? In other words, was there a formal policy on Audi letters?
In such a policy on Audi letters.
And was any directive given, in a written directive, given to line managers on how and when to use Audi letters?
No, there was never, such.
I understand in your affidavit, I understand your staff out of loyalty asked you to send them Audi letters. For example, on the 6th of August 2019, you send an Audi letter to your direct reports. These were identical letters then on the 10th of October 2019, written warnings were sent to the staff. How then did the Audi letters fit into the disciplinary policy and procedures that require a formal verbal warning to be given?
That was another gap, because of then there would be, instances where you would give those Audi letters. So it didn't fit into the disciplinary process, as such, because of, in my instance, this was related, to investigations, and where there were, areas of misconduct, which I never had, an employee that I was supposed to subject to the disciplinary hearing. I never issued such an Audi letter. So the Audi letters that I've issued, would emanate also from the meeting, that you go into the meeting and then a decision is taken that you need to issue those Audi letters, and one would have to implement the decision of that governance structure, which is the dashboard meeting.
Are you aware of other government department or private companies where Audi letters are used rather than labor procedures?
I am aware that, for instance, before, issues around Audi letters, yes, they are given where you've got, evidence of what, the issue is all about. But in our case, from the Audi letters that, we have given is, it was a matter of, the issue is done, people have not performed, and it was related to performance management. But again, not really performance as such, but not meeting the deadlines, which, ultimately will translate into performance management, although we knew, the circumstances around it. But when we talk about, an Audi letter, for instance, in a government department, you would give somebody, such, a letter when you have established all the facts and you are sure that, what you are talking about, you needed to do that. So as I explained earlier, that, in terms of how the Audi letters, are being issued, when you look into the matter of Mr. Jeff Wexstrom, that, I had Muhaladi a letter, and meanwhile, the issues have not been thought through, they are not known, and it's not validated as to what delays, such, a response.
Thank you. As an experienced leader and manager, would you use Audi letters as a normal performance review tool?
I wouldn't.
And
I would use it as a last resort I would use it as a last resort when, before I even go into disciplinary hearing, when I have established, the circumstances around, performance.
You had a long discussion on target setting today. Should target setting in the context of performance include barriers to performance and evaluation of resources in order to achieve those targets?
Correct.
Was this done by the public protector when setting targets?
No.
Did the failure to include these factors in target setting damage the Public Protector South Africa as an organization, in your view?
For me, it's not really damaged, but when I spoke to the staff members, it created that uncertainty, anxiety, and fear that if you cannot manage this, then ultimately you're gonna get an Audi. Which at the end of the day, when obviously when you've got unhappy employees, they would not actually do or execute their work under those circumstances. So there was never an opportunity to deal with such matters. But also when I looked into this kind of Audi, that the way they were implemented in some instances, there are people that would lose a case, or their case was set aside in court. And if we talk about that, I think those people also, if we didn't have a framework on how do we deal with such cases, and nothing was happening to them. There were people that in other provinces, like KZN, didn't have, reports that were submitted and published more often than the cases, in some other areas. So it was a matter that, some employees will raise, for instance, that, why are our cases, always prioritized, for publication or for finalization, when others, they could have time, to deal with those particular cases, and the reasons provided, seem to be accepted.
Thank you. You mentioned a project plan that you drew up to deal with the backlog. Other than the broad project plan that you drew up, did the PPSA have individual project plans for high profile or large reports? And how was staff leave accommodated in those project plans?
We didn't have a project plan as such, for investigations, but what we have was a project plan, for cases older than 2 years. And we also had a task register where, with all other cases, you actually register how the progress on those particular, cases. So that's how, we dealt with, the documents that would guide, in terms of projectizing or classification of cases.
So did the PPSA use project management software or subsystems like MS Project on those?
No, we didn't have such. It was a normal MS Word and Excel document that was developed by customer services unit, to deal with those matters.
Could I ask you, and this is my last question, how many years experience do you have at a senior management level?
I've been at senior management level since 2001.
Chair, may I venture to, I said it's my last question, just to ask this last one, which is, you mentioned very briefly with Honorable Manyanyiso the impact of everything on yourself and then on several of your colleagues. Would you mind telling the committee, what did this have as an impact on you personally? And what would you say in terms of the impact to your colleagues when you speak of the different issues that you were confronted with?
To be honest with this committee is that, I would have, sessions where the 3 executive managers that reported to me, that is Mrs. Mohaladi, Ms. Mutsetse, and Ms. Tejan, would literally break down in the office and cry.
Thank you, Mrs. Baloyi. Appreciate you coming here.
Thank you.
Thank you, Honorable Sukas. Honorable Milan.
Thank you, Chairperson. Good evening, Ms. Baloyi.
Good evening.
Ms. Baloyi, hello. Ms. Baloyi, you stated paragraph 11 of your affidavit that the PP's way of overseeing investigations was not to hear or listen to the executives and investigators responsible for conducting them. Her chosen method was to threaten, impose, and brook no other views. My question is this: did the PP subvert or amend the findings of investigations based on her personal opinions rather than on a factual or legal basis?
I would talk about, investigations in the sense that, for me, it's when the evidence is before you, you need to deal with that matter in that particular manner. But, when you look into how, some of the matters have been dealt with, as I stated with Nkwinti, we're supposed to finalize those that report, and make certain recommendations because of, someone internally had to, benefit out of that particular investigation. Remember that, it's unprecedented that, you can appoint, an employee on a 1-year contract, for such a level of position without even running a particular process. So when you analyze, that and what one was subjected to, I came to that conclusion because of, one had to remove certain information because in the first section 7.9 that was issued, the Deloitte matter, the report that I stated earlier that implicated Mr. Mahlangu was there, but then it was later removed, from that particular angle. So for me, when you look into what we're doing and what it was supposed to, deliver at the end of the day, and given the fact that a matter that is in the labor court might be saving there for quite some time, and why don't, if there were good intentions to appoint him, he could have been appointed with the condition of, based on the outcome of the labor matter, which was known that, it was financial mismanagement. I didn't find any reason why you could be appointed on a 1 year, and again, that appointment is dependent on the outcome of the Nkwinti investigation.
Yeah. Ms. Baloyi, you say in paragraph 14, the public protector's pressure on me and other executives to take disciplinary measures against staff who reported to us was relentless. Did that take up a lot of time that could have been better utilized to investigate or draft reports?
It would take time, yes. It take a lot of time depending on the complaint that was there. Remember that you need to address the complaint. By the time you finalize the report, you could have dealt with matters that appropriately. And when we look into the issues of disciplinary hearing, as I stated, that the investigations were not necessarily done by the executive managers. And for me, if that report was, for instance, that matter was investigated by a junior investigator, it would mean that, when I get an Audi, it will have to be cascaded down to everyone. So can you imagine that, would end up with a lot of employees that are grieved, people not being focused because of in dealing with that matter, it would be an Audi. So it will be a ripple effect that I get one, the executive managers give it to their chief investigators, the chief investigators give, written warnings to the other, senior investigators and ultimately the junior investigators, because of that's where the work emanated from.
A lot of time then.
Yes.
Okay. Ms. Baloyi, at paragraph 19, you talk about the long hours of work and the constant pressure to put out reports to coincide with media briefings. And then in paragraph 20, you note that this adversely affected the quality of reports because investigations and the preparation of reports were rushed. Now, my question is, was this the norm, or did it only occur in exceptional circumstances or with high-profile cases?
It was it coincided with high-profile cases that, as I stated earlier, there was an FSB case which, on the 22nd of, the 24th or 26th of March, then we got an instruction that it should be one of those. And at that stage, not much work has been done. The issues of the attorney, appointments. So in most instances, that was a challenge, with us that, we are dealing with a matter to be publicized on this day, regardless of the work that could have been done properly.
But it's the high profile ones that pushed the attention and the long hours and the like.
Correct.
Okay. Who were the investigators on the external investigators on the CR17 matter?
I do not know. That information was never divulged to me.
In your testimony earlier, you said that when you met with Mr. Mahlangu and the Chief of Staff, they resisted your suggestion that the NPA was best placed to investigate the CR17 money laundering allegations. And you further said that during that meeting, you were told that the matter cannot be delegated to the NPA and that the NDPP will not actually deliver the results wanted. Is that correct? Did I understand you correctly?
Correct.
Okay. So what were the results that were wanted and who wanted those particular results?
I wasn't sure because of, when you discuss a matter with your team, and then later on you find that those matters have been escalated to the CEO. So it was not an engagement, but was just to inform me how this investigation should be done. And I didn't have much to say in that particular meeting, but I was told that I should stop insisting that this matter should be dealt with in any manner.
So that brings me to my next question, which is, what was Mr. Mahlangu's role with regard to investigations?
None.
And how often did he get involved in investigations?
When you say involved, he was never even involved in investigations, and he would just receive reports as in any other, in terms of that, or when a particular issue is being dealt with. But he wouldn't actually tell you what some of these matters are all about, except for when we report and we explain what the issues are. But he was not involved in investigations, and specifically that if he was involved, he would have played a very crucial role in providing input, support, and guidance in my work, which never happened.
But I mean, we've heard throughout this inquiry that he would make inputs into the findings and recommendations and remedial actions of reports. Is that not true?
I am not aware, except for when it was one or two cases which were dealt with by one person, that, as I stated earlier, on two particular cases, and when I was asking this particular investigator, why did you change, the content, and was said that, it was my discussion with the CEO, which was unusual because of, we never reported to him on the content of the investigation, and he never signed any investigation report.
So that was out of order. Okay. Was the public protector aware of his involvement?
On the cases that, for instance, I was not happy about, I discussed it with her.
Okay. I want to come back to the public protector's chief of staff, Mr. Sibusiso Nyembe. What was his role in the organization?
His role was that of supporting, the public protector in managing his office. And with regards to investigations is, I would submit the reports to the public protector, through him, that, you'll check it and sign it off for the public protector. So that was his role. He was the actual chief of staff managing the administration office of the public protector, and including, managing the correspondence that goes in with related to investigations.
Okay. what do you think he meant by the statement? And I quote, "The report will be dealt with in this office and the PP will emerge as a powerful woman in the country after dealing with this particular matter"?
It was a matter that,
Chairperson?
Just pause. I'll go them both.
Yeah, thank you. No, I wanted to object to the editorializing by Honorable Milham. He says that the witness said something about the most powerful woman in the country. There's no such evidence. Those are his words. The other objection about respecting the departed, I don't think he will understand the issues of Ubuntu. But can he just not put words onto the mouth of the witness? Thank you.
Chairperson.
Okay, before you respond, thank you, Advocate Mpofu. I think Honorable Milam would have referred to matters in the affidavit.
No, I'm not talking about any affidavit. I'm talking about the testimony.
Okay, Honorable Milam.
Chairperson, I was quoting what was stated earlier, where Mr. Nyembe reportedly said, "This report will be dealt with in this office and the PP will emerge as a powerful woman in the country after dealing with this particular matter." I never used the words most powerful. I said a powerful woman. That was what was testified earlier. Now, my question is, what does Ms. Baloyi think Mr. Nyembe meant by that statement? What did he mean to convey to her by that statement?
Well, Chairperson, it's fine. Let him continue. I don't think he'll get it here. Thanks.
Thank you, Advocate Mpofu. Ms. Baloyi.
My understanding was that, that is a crucial investigation that, at the end of the day in history is that he even said it, when we were talking about it, to say that, the cabinet could have been will be collapsed within a short space of time, and that would be history in the country.
And the emergence of the PP as a powerful woman in the country?
Yes, that, she would have dealt with an investigation that within a short space of time, that cabinet would have been collapsed.
Okay. My last point, and it continues on the same train, I'm going to ask the evidence leaders to put up a tweet of Mr. Nyembe's, and I'm going to ask you if you think it is appropriate. This tweet has been provided to both the public protector and the evidence leaders. Could you put it on the screen, please?
Chairperson? Chairperson? Yes. Yeah, again, we object to this abuse of somebody who cannot answer for himself or who cannot, I get also Facebook messages attributed to me. I'm not even on Facebook. There are all sorts of imposters, but I can answer for myself because I'm alive. But this is now abusive and inhumane, and even coming from where it comes from. Thank you. So I just think that for you to allow this, Chairperson, you are being insensitive both, not just to Mr. Nyembe, but to his family members. And it's not done, this. First of all, Mr. Nyembe, this is not the impeachment of Mr. Nyembe. And there's nothing in the motion that mentions him. The motion of the former Chief Whip Mazoni does not mention the Mr. Nyembe. I'm sure Honorable Malem would know that because he would have looked at the motion. So this is just pure abuse for no gain at all, except to be abusive and gratuitous and inhumane and cruel. But that's
Chairperson,
fine.
my question goes. Chairperson, my question.
Thank you, Advocate Mpofu. I will watch the space. Honorable Milam.
Chairperson, my question goes to the role of Mr. Nyembe and the impartiality of the public protector, which is a constitutional obligation of that office. And it's a bit difficult to read, but it basically says, and this is Sibusiso Nyembe, and his Twitter handle is @SoDonkey.
Chairperson, I've made an objection. You have not ruled on it.
Chairperson.
Chairperson, I'm sorry.
Being interrupted, Chair. I'd like you to protect me, please.
Okay, I apologize, Mr. Milam, but can we wait for the ruling of the chair, please? At least, can we pretend that this process is being managed with this dignity and sensitivity that...
That's quite rich coming from you, Advocate Mpofu.
I did not ask you to do that.
Listen, yeah, Milam, don't do that. Don't do it.
I did not ask you to make such response.
Don't do that.
Chairperson, I'm not going to take this from Advocate Mpofu. He's been badgering weeks
do
now.
Not do that.
He has been disrespecting you. He's been disrespecting members of this committee. Disrespected Honourable Mulder today. He continues to speak over people when other people are talking.
I'm not talking about... No, I'm not...
Chair.
Listen, Mr. Milam.
Honourable Milam, please switch off.
Mr. Milam.
Please just pause, Advocate Mpofu.
No, Chairperson, no. I'm not going to be abused by these people.
I'm asking you to pause.
I've
asked Honorable Milam, who's on the platform, to switch off his mic, and I'm asking you to stop.
Yeah, I'm stopping to talk, but I'm telling you, I'm not going to be abused by these people.
I'm asking you to stop, Advocate Mpofu.
I'm not going to be abused by them. This is another era now. This is not the same.
Advocate Mpofu, I'm asking you to stop talking.
No, man. Sorry, Chair. Apologies. Okay.
It's not going to help that you get to just slag each other on the platform and so on, because we've got to get to the bottom of the issues that brought us to be here. Advocate Mpofu, you're raising an objection.
Yes.
And your objection is on the basis that the person being referred to is late, and therefore you're invoking issues of dignity in relation to that. I've listened to that.
And relevance, sure.
Yes. From this morning, in the affidavit, the name of Mr. Nyembe would have been mentioned and reflected on. So that's your beginning of the relevance in terms of what we're focusing on here today. You might not like that, and I don't want you to respond to me. So I am going to ask Honorable Milam to complete his question and hear what the witness responds, how he or she responds to that. We're not going to be getting into the personal life of Mr. Nyembe here. What we're dealing with, we're connecting the dots here about the issues that have been placed in front of us. And I will watch that space when it gets into that private space that encroaches on dignity. So for now, I am comfortable that we're not in that space. And therefore, I'm ruling that Honorable Milam continues with his question.
Thank you, Chairperson. Can we put that back on the screen?
Can I just say something? Excuse me, Mr. Milam. Yes, Chairperson, that's your ruling, and I respect it. All I'm saying is that I just want to place on the record that you should know better, that you cannot abuse somebody who cannot answer for themselves about material which is not before this committee, about material which is not relevant to the impeachment of the public protector. But if you want to use this platform to desecrate the memory of Mr. Nyembe and to, assault the dignity of his children and his family, be my guest, Chairperson. Thank you. And Mr. Milam. And anyone else. And anyone else.
Thank you. Thank you, Advocate. Thank you, Advocate. Can we put
and Ms. Mazzoni and everyone.
Can you fly to the tweet?
So, Ms. Baloyi, the tweet is the one in the middle there, and it's dated June the 10th, 2018. And it says, beyond dispensing political economy and socio-political advice to PP, I also jerk up legal services on certain high-level litigation matters like CX, ABSA, and Frieda Dairy Farm matter. My question to you is this: in your opinion, does this compromise the public protector's constitutional obligation to impartiality?
Chairperson?
I want to acknowledge you, Advocate Mpofu, and I'm hoping it's not on the same issue that I've just rolled on.
No, it's a different issue, Chairperson. And it is...
Thank you.
Yes. Can Honorable Milham confirm who sent that tweet? Because there are thousands of people called Sibusiso Nyembe in South Africa.
Thank you, Advocate Mpofu. We got the question. Honorable Milam.
Chairperson, the tweet was issued by Mr. Sibusiso Nyembe, who at the time was the so-called political advisor to the public protector. His Twitter handle was @SoDonkey, and it is his Twitter account.
How do you know that?
Ms. Baloyi?
No, Chairperson.
Please respond.
Chair? I'm sorry.
No, Advocate Mpofu. The answer has been now provided. Who issued the tweet?
No, but that's not an answer. How does he know what Twitter handle? This is a process, Chair. This is not a shibin. So you can't just say that this was his Twitter handle. He must demonstrate that that is so. If he wants to abuse his name as he continues.
Show it on the screen.
Thank you. Please, I want you to pause, Advocate Mpofu. Can you fly to the tweet, please? And then Ms. Baloyi, please respond.
Chairperson, immediately under Sibusiso, or immediately next to Sibusiso Nyembe, you can see the Twitter handle. It says @SoDonkey, and it says June 10, 2018.
So who's the
Ms. Baloyi?
Who's the donkey, Chairperson?
No, please, Advocate Mpofu. I don't want us to go to that level.
No, Chair. No, Chairperson, you must make a ruling. I am saying that...
I've made a ruling on this issue. I'm not going to repeat the ruling.
Yeah, but it's based on what, Chairperson?
Baloyi to answer the question if she's able to answer the question.
Do you know Sodonki, Chairperson, or don't you?
There are many tweets that were here. We never went to track who this is in the name of this tweet. We can't be doing that.
Yeah, but they were not for deceased persons. We have to protect our people. If you don't want to protect the dignity of black people, we will protect it. The culture of black people is that you don't abuse those.
Thank you, Advocate Mpofu. I've asked you to stop.
You must know that.
Ms. Baloyi, can you please
whatever agenda you are pushing, you're not going to abuse us forever.
Ms. Baloyi, please respond to the question.
Thank you. This tweet, Chairperson, I see the date is 10 June 2018, and I'm not sure why it was done, because of and under which context, especially the first one, that I was not aware that or I don't know the issues around that. And I think the second one is just being expressed. So I wouldn't say whether, if it's really the late Mr. Nyembe was doing it in his own personal capacity, or he was actually authorized, to can do so. So I'm not aware of the context of this particular, tweet.
Thank you, Ms. Baloyi. That would have been your last point now.
Yeah, Chair, I didn't get an answer to her opinion about the comments in that tweet?
Chairperson, that's irrelevant.
Ms. Baloyi.
The opinion. Chairperson,
Ms. Baloyi. Ms. Baloyi, I've recognized Ms. Baloyi, not Advocate Mpofu.
Okay, well,
Ms. Baloyi, please respond.
Thank
I need to talk, Chairperson, I need to talk before the response. I'm objecting.
Ms. Baloyi, please respond to the question.
Thank you, Chair. When I think we
Chairperson, I'm raising an objection before the answer.
You can't be dictating when you want your answer. If you're raising a hand, I'll recognize your hand. For now, Ms. Baloyi is responding to the question, and don't interfere. Ms. Baloyi, please respond.
With regards to the first tweet, I think if you can share it again so that I can respond appropriately.
Sorry, ma'am, I'm still addressing the chair.
Ms. Baloyi, please continue. I have asked you as a chair. You don't have any other chair here. Ms. Mpofu, I've asked you to pause and wait for Ms. Baloyi to respond. Please go ahead, Ms. Baloyi.
As I stated, in terms of my opinion with that, the first one, I wouldn't know what, political, economy and socio-political advice, provided to the PP, but about the latter, it's something that I think when I look at it, it's a statement that says that, he actually assists on high-level litigation matters. This is a person that has got a legal background and being a chief of staff that if asked, probably would do that particular job. But as I stated, that I'm not sure what was the context on this particular matter. And with the second one, for me, when I read it, it was, an opinion around, the funding, in the organization, but the appropriateness, I'm unable to respond on that because of, I'm not sure whether he was authorized then, to can deal with this particular matter, but I just see statements, being made with regards to these matters.
Thank you. Before I go to the next speaker, will be Honorable Mkweba, the second last speaker. I come back to you, Advocate Mpofu. You wanted to raise something?
Yes. Well, it's overtaken by events now. I said I wanted to raise it before the question is answered. But for what it's worth, the point I want to register is that this is on you, Chairperson. If you are going to allow this abuse of Mr. Nyembe, you are the one who's responsible for it, not the misguided questions regarding his alleged tweet, which we don't even know whose tweet it was. So you must take responsibility for that on behalf of whoever you are acting for.
Honorable Mkweba, I recognize you.
Thank you very much, Chair, and good evening all. Ms. Baloyi, I've got only 3 questions for you. Firstly, Ms. Baloyi, in your affidavit, paragraph 3, you have stated that you believed that you believe that you were purged. And again, in paragraph 4, you also stated that you were informed of your employment would not be confirmed beyond the probationary period. And during the day, you have also indicated that you have never been assessed for your performance. So, Ms. Baloyi, do you believe that your rights were infringed?
Thank you for the question. Yes, because of I should have been dealt with in terms of, the prescripts that were there, and in essence, it's when even some of the allegations were made around the non-confirmation of my appointment. I would have expected, that kind of an office to be open with me and stipulate what those areas of misconduct are all about, who has actually, divulged, certain information to who, when. I mean, when you deal with an employee, obviously somebody, the facts could have been put up front to me, but the manner in which, this matter could have been dealt with, for me, it was violating even my rights to say that, a person that has been in the public service for years, with top security clearance, that, I would have discussed that. I would have expected that if it's true, the matter be brought forward, so that I can be able to defend. And the manner in which, issues unfolded with regards to, when I was informed that my probation was not confirmed, I didn't see any reason why I should vacate the building, and not even, work, throughout the week of October, as if it was I was a risk. And for me, it was a matter of just humiliating me in essence. And in short, yes, I felt my rights have been violated.
Thank you very much, Ms. Baloyi. Then in paragraph 24 of your affidavit in the High Court challenging your dismissal, you have indicated that you were a stumbling block. And please clarify why you consider yourself to have been a stumbling block for the CEO and the public protector.
With regards to the stumbling block, it was a matter that was advanced to me by Mr. Mahlangu that it looks like I'm not towing the line, and I started I'm doing things without applying my mind, and there are matters that I could have dealt with differently and with regards to investigations. And my worry was, if those issues were discussed thoroughly with me as to why did I take such a decision or allowed investigators, not to deal with this matter in that particular manner. Surely that could have been discussed with me, but rather being told that, you seem to be working, on your own, with investigators, doing your own things, and without, in some instances, even divulging those kind of issues. And he told me that, you cannot be trusted when you deal with matters like that. And, that I'm not dealing with issues, correctly. And that, for instance, this matter again came out when we discussed, after that matter of Mrs. Mokhaladi, to say that, you should have, dismissed a long time ago, with regards to that. And I couldn't. And even today, I asked myself why I should have dismissed her. And interestingly, when I was dismissed, she was also suspended with other colleagues. So for me, it was, a matter that was communicated to me, but not really a stumbling block to say that, there are certain matters that if concluded, they could have served a particular purpose. But my question kept on being that, why are these things not said in a formal manner or, in a way that I would understand, because of the work that we were doing was informed by the evidence before us.
So do you think that the CEO was abusing his authority at the behest of the PP?
Correct.
Then the last question, Ms. Baloyi, you have raised concern in your affidavit, the manner in which the public protector handled the cases relating to Busasa and the Rock Unit investigations. And you have said in your response it was unlawful. Is it your evidence that the PP did not act in an impartial manner during these investigations?
Yes, when you look into the gaps in those particular reports that I've raised.
No, thank you very much, Chair.
Thank you, Honorable Mkweba. Honorable Maneli.
Thank you, Honorable Chair.
Go ahead. You're recognized.
Thank you, Honorable Chair. Greetings to members, the team of the Public Protector and the Public Protector, as well as the evidence leaders and the witness to understand. Greetings, Ms. Baloyi.
Good evening.
And through you, Chair, my first question really would be the assertion made by the PP in a message to you regarding the Busasa and CR17 investigation that, in a quote, it is not about you, but one has to play the chess, close quote. Do you think in conducting this investigation, the PP didn't look really on facts before her, but went beyond facts before her?
Chairperson?
You did not raise your hand, Advocate Mpofu. I will not continue allowing. And if there's no hand of you, it's only raised now.
No, it was
okay. I recognize you. What do you want to raise?
No, I was just wanted to assist Chairperson. The message that the honorable member is talking about had nothing to do with the CR17 matter. Thank you, Chairperson.
Thank you. Advocate, Honorable Maneli.
Chair, I've asked a question and I read the quotation. I would expect Ms. Baloyi to indicate if it's an irrelevant question. Thank you.
Chairperson, can I ask that, Honorable Maneli repeats the question? I was a bit distracted.
I've asked the question, Chair, that the assertion made by the PP in a message to you regarding the Busasa and CR17 investigation, and I quoted, it is not about you, but one has to play the chess. And the question was, do you think in conducting this investigation, she looked beyond the facts before her? That was my first question, and I was to follow the question once I understand your answer. And of course, I got distracted in that school. And if you think the question is not relevant, you'll be indicating that. That's the point I was making, Chair.
Thank you, Chair. I think, as I stated earlier, that the investigation could have been dealt with differently, and I think this is a report that has been set aside in terms of what the court says. But as I stated earlier, that I've made submissions on our concern on how to deal with certain matters, and including that particular matter because of the SARS matter or the other Pillay matter. It was a matter of the content of that report was correct, but the issue that has been challenged in the courts was around that matter has prescribed. So in terms of what has been spoken about as far as that case is concerned with that chairs, I had Advocate Mpofu that it was because of probably the sabotage, which I indicated that I'm not aware of such sabotage.
Would you then think, through you, Chair, that that approach would have also brought the Office of the Public Protector into the political arena as opposed to straight investigations just that need to be done like any other complaint that come before the Public Protector?
Correct. When you look at the camp, what does the camp mean? on such an investigation. And the fact that, which also becomes a problem to me and, those that were probably, concerned about the content and the performance of the investigators involved is if we knew or were made aware of who those investigators were, probably I would be able to answer that question adequately.
Through your chair, if I may proceed, in paragraph 61 of your court affidavit, you indicate that the reports, like you've just said now, were dealt with by external parties who reported to the PP directly. Do you think this led to the Office of the Public Protector incurring unnecessary costs, which could be seen as reckless or wasteful in nature? Or also whether do you think this also impacts on the independence of the Public Protector's office?
Thank you. When you look into that statement that was officially, issued in the media by the spokesperson of the Public Protector, that this was a high level, kind of an investigation. My assumption is that, those people have got top security clearance and they had the competency to can do that particular report. And I'm not privy as to whether they've been paid or not. That if they have not been, for instance, cleared, and they were supposed to have, information that is in a state institution on the position of an institution, obviously those people could have been cleared. But today I wouldn't talk about whether they've brought the office into disrepute because I'm not even, I don't know the profiles of those individuals, including their competences and qualification to handle such a case.
Through you, Chair, if I may just to wrap up on that point, given that you have a system in place for quality assurance where people will take responsibility, how were situations like this one treated in terms of ownership by the different levels of quality assurance where they've not been involved?
This was a unique case, as I stated in my affidavit. It was never done before that I'm aware since I've been there. That I'm not even sure who quality assured that particular report, because of the only time that I had an opportunity to have sight on the content, it was that day when I was supposed to be part of the team that went to deliver that Section 79 to the President. But as to the finalization of the report, I never saw the final report except for when it was the time of the briefing, and I didn't even have copy myself. And I remember quite well, Mr. Mahlangu and I did not have copies of that particular report when it was delivered. And on the day that it was publicized, it was the only report that was released.
Maybe my second last question, just to complete this part about this investigation in particular. Of course, I would refer to what you've read already about Mr. Watson mentioning other political parties as having been funded, including the NTZ aspect, and you tried to explain this. I want to be sure that I've taken correct notes, Chair, that these points are raised, in your view, from a point that these matters, because they have been mentioned, should have been part of a report, or that if they are not part of the report and they're limiting it to the 500,000, that those matters could still be reflected in the report to be matters to be investigated elsewhere other than with yourselves as the public protector. I just want to get that point, Chair, so that I know the relevance of bringing those two paragraphs, 5, 9, and 6.
Correct. Even if they were investigated, then they should have been, made mention of those issues in terms of reference. And normally when we conducted an investigation and we realized that we do not have the mandate to deal with such, and a letter will be written also to those institutions, whether it's the NDPP, the Hawks, or the South African Police Service, or any other structure, to further investigate or look into those particular matters, and then would request progress reports, on those particular matters.
And through you, Chair, in your view, that will still constitute in the quality assurance the advices that usually would be given to the investigators in case there are areas that needed particular attention without interfering with their work.
Correct.
My last point, therefore, Chair, in your observation then, did the PP abuse her authority in any way as the public protector, having shared all what you've shared with the committee?
That's very good, Chair.
Thank you, Chair.
Did you get that? What? Just repeat that.
You want me to repeat, Chair?
Yes.
Okay. Now the question is, in Ms. Baloyi's observation, did the PP abuse her authority in any way as the public protector, given all what she has shared with the committee?
Thank you. Ms. Baloyi?
Chair, I would say that, yes, but it will be up to the committee to decide. But in my view, in the manner in which, some of the matters have been dealt with, that was an abuse of authority.
Okay. Okay. Thank you. Thank you, Honorable Maneli, and thank you, Ms. Baloyi. And now yield back to the evidence leaders in terms of 616 and 617. If you have any questions you want to pose.
We don't have any questions for this witness, Chair. Thank you.
Okay. Thank you very much. Ms. Basani Baloyi, we've reached the end point of interacting with you. We want to thank you for availing yourself before today and today to come to this Section 194 committee and place your evidence and respond to questions from the evidence leaders, the cross-examination from the public protector, and as well as the members. And we hope that what you'd have placed here would assist this committee in its deliberations and its conclusions. Do you have anything to say?
Not at this stage, Chair. Thank you.
No remarks you want to say to the committee? Or more questions?
I think from my side, I would like to thank you and believe that, I have assisted you in terms of, your work. And I'm grateful that, I could live to this day, to can be able to do that.
Okay, thank you. You are excused. That will be our last point for the day. We'll have a new witness tomorrow. Before I conclude, I recognize you, Advocate Mpofu.
No, thank you, Chair. I just wanted to register the fact that we have not finished our cross-examination of this witness, and maybe you can indicate to her, well, some subject to whatever arrangements will be made with the evidence leaders, that we will take the opportunity to do so at a later stage.
Thank you, Advocate Mpofu. In terms of our committee decision of last week, we have enhanced our processes, and I hope that the team will be in touch with you, which indicates that where there will be a recall for a witness, we're going to require specific areas of focus and questions to that witness. And so when we, therefore, based on that, we switched on the recall of the witness. So there's going to have to be that interaction. At this stage, this is where we will leave the matter.
Is that a new rule now, Chairperson?
That's the decision of our committee, and I think we will have to make sure that you fully vest with that. But I've noted the points you've put on the table. Thank you very much.
Thank you.
Thank you. The meeting is adjourned.
Thank you, Chair.